Next.
Item number 3.
My lord, item number 3, I beg to appear for the petitioner, my lord. As being the officer of my lord's court, my lord, it is my duty to point it out. My lord, perhaps this matter will not be heard out over here. It will be because this matter pertains to Jalpaiguri district, my lord. My
No.
lord can see this is a matter related to Jalpaiguri district. My lord, my humble prayer is that if my lord can send this matter to over the circuit bench, then my lord, that perhaps the circuit bench at the Jalpaiguri has the proper jurisdiction to hear out this matter, my lord.
এটা একটু একে জানো তো 13 সালে যেগুলো আছে জলপাইগুড়ি সব ওখানে চলে যাবে কিনা জলপাইগুড়ি 13 সালের ফাইলিং জলপাইগুড়ি কবে স্টার্ট হয়েছে
It's 2019, my lord. 19 began from 2000.
নোটিফিকেশন ওয়াইজ কি 13 সালের মামলা কি জলপাইগুড়িতে যাবে এখানে
May I suggest one thing, my lord?
জানো না তো জেনে নাও
My lord, may I suggest one thing? Perhaps my lord is visiting the circuit bench next week, my lord. What I was suggesting, as my lord has heard the matter, if
No, it will not go to the circuit bench. Whether it will go to the circuit bench or not, that is to be ascertained from the department because 19 it has been established, Jalpaiguri. Prior to that, there are many matters of Jalpaiguri which is being heard by this bench.
my lord, my lord, it was
Come
my duty
tomorrow,
to point.
tomorrow.
Can it be day after tomorrow? Tomorrow I have some personal difficulty.
Kindly on Friday, my lordship.
Friday, my lord, if it can be.
Mr. Galib is my lordship.
Hi, Mr. Galib, Mr. Galib is leading, my lord, from the state, my lord.
Friday or next week, my lordship. Whatever it is.
I have some difficulties, my lord.
Lordship, reply has not yet been filed, my
Yes,
lordship.
my lord. Mile has granted me liberty, my lord. Reply has not been filed, my lord. It has been prepared, my lord. As the petitioner is from Shiliguri and she is suffering from medical condition, my lord. She will be. She has ensured that she will be coming this week by file it. Then, my lord, kindly keep it on Monday, as my learned friend has
Monday, I will not
prepared. No, then Friday, my lord. Kindly keep it on Friday, my lord. Kindly keep it on Friday. Well, kindly keep it on Friday, then, my lord. My lord, then kindly keep it on Friday, my lord, because my lord, I have a hearing matter going before courtroom number 8, my lord. My lord.
Well, let me ascertain from the department.
My lord, my lord, my lord.
Why did you submit then?
My lord, it is my duty, my lord, as a officer of this court, my lord, it is my duty, my lord.
Friday the regular. On the prayer of Mr. Aditya Mondol, an advocate appearing for the petitioner, list this matter on Friday.
Grateful, lordship. Grateful.
Friday.
The reply should be filed earlier, my lordship.
But if we are filing a reply, I will serve an advance copy before Friday, my lord.
Because
By
my lordship, today was the last day. It's not filed yet, my lordship. It can be.
I will serve an advance copy to them so that on Friday, if the matter is taken up, matter can be heard out properly.
Then it has to be extended.
My lord, kindly, my lord.
Mr. Aditya Mondol, an advocate for the petitioner, seeks extension of time to file affidavit of reply, if any.
Last occasion was the last day today, my lordship.
And he seeks short argument file the same.
But
With
by
this matter.
Thursday, my lord. By Thursday. So that they can come back prepared on Friday, my lord.
List this matter on Friday.
Grateful, lordship.
Friday, 7.
Item number 4.
On behalf of Mr. Asharful Haq, I am praying not this week, Lordship. Due to his illness, he is not come in the court.
Although this one is represented. এগুলো কি মেনশনিং এ আসছে এটা মেনশনিং হয়েছিল On the prayer of learned advocate for the petitioner, list this matter in the combined monthly list of February 2020.
My lord, is this item 5, my lord?
4.
My lord.
Item number 5.
I
Hi, my lord, Mr. Shibujyoti Chakraborty is appearing online for KMDA.
My lord, Shibujyoti Chakraborty for the KMDA HIT wing, my lord. On the last occasion, my lord, I had mentioned that the KMDA has already merged with the HIT. I'm so sorry, HIT has merged with the KMDA.
Hmm.
And my lord, all the affidavits have been filed on behalf of the state as well as the KMDA, my lord.
My lord, your lordship kindly have a look to the prayer is this. Acquisition proceeding was initiated in the year 1979-80
Page number.
under 1894 Act.
Page number.
But your lordship, writ petition. The writ petition, my lord, at page 44, your lordship goes up the question on the Right to Information Act.
Oh, acha.
And reply, I placed this matter before your lordship for the last occasion. And your lordship will find my structure, land with structure has not been taken over possession. And the petitioner has not been paid any compensation money, my lord, in the said proceeding. So that is why, my lord, it was paid for release of the property from the acquisition proceeding. And as the 2013 Act came into force from 1st January 2014, therefore, my lord, that 1894 Act has already been repealed, your lordship knows that. But what has happened, Milo, in the meantime, we are living there and they have stated in their report, page 45, your lordship kindly have a look. The paragraph 5, your lordship kindly see, page 45, P6, dated 29 January 2016, your lordship kindly have a look.
Hmm.
Possession in respect of vacant land measuring an area of 1 bigha, so and so was taken, leaving an area of 8 shota covered by structure. So, this property with structure has not been taken over as yet, and no compensation money was paid. So, law says that certain principle of law that the acquisition process initiated in the year 1979 to lapse in the meantime. Therefore, a prayer was made, applications were submitted before the concerned authority for release of the land. You are not taken over possession and no compensation money was paid. This was the prayer. Then they admitted that structure with land with structure has not been taken over. To their own admission that was the report was submitted by special land acquisition officer.
What is the state saying?
I know
State.
page 45 of writ petition, your lordship.
What is the report of the state?
So now, Lord, I have placed the document used in the affidavit, report in the form of affidavit by the assistant land acquisition officer. The report in the form of affidavit on behalf of the respondent number 2, 3, and 4, your lordship. 2, 3, and 4.
2, 3, and 4.
Your lordship, kindly on page 8 of the report on this. Page 8, top, your lordship, kindly have a look to LA case number 155 of 1979-80. Have you lordship got it, below? Page 8 of the affidavit is the form of affidavit on behalf of respondent number 2, 3, and 4. Page 8. During the said order, your lordship will find notification number blank, published at blank, declaration blank, published at page, all are blank, my lord. Unless the dates are not, my lord, disclosed by the concerned authorities, my lord, this, how can that, my lord, be decided that whether the entire proceeding has been last or not, that I do not know. I am praying for release of the property in respect of 8 quota with structure. I'm praying for declaration in the address also, not the whole proceeding. Neither the land acquisition officer nor the KMDA disclose those dates. In spite of submission of my reply to the exception to the said report. Moreover, below the petitioners had been paying rent. Their names are appearing in the LR record of right, which I have annexed in my this petition as well as exception.
We saw the state.
Something very Mahato is appearing for the state, my lord. He is coming, my lord. Kindly take up at 2 p.m.
Yes, my lord. If it is taken up at 2 p.m., I will also be present, my lord. I am also humbly praying. I have some submissions to make, my lord. If it can be placed fixed at 2 p.m., I humbly pray. I leave it to my lord.
I don't know whether I am able to come here in that building. When matters are there, I cannot say before your lordship that yes, I shall come back. Your lordship kindly fix a date, then I shall come back.
Certainly, my lord. Certainly.
Your lordship will find from the record that how many times they have taken adjournment, prayed for adjournment. Again and again, my lord, they have taken time according to their own choice.
For that reason, my lord, I am praying that it may be fixed 2 p.m. Since my learned senior is having problem, I leave it to my lord. Because I am actually in state commission for a government matter, my lord. So I had to come. I tender my unconditional apology for the same.
Learned. Mr. So-and-so learned advocate for state respondent seeks accommodation. Technology did borrow. Gives this matter on. Well, 12th February.
So grateful, my lord.
At 2 p.m. your lordship.
Madam, in the second half, I am taking up original matters.
Yes, my lord. I am absolutely sorry. Yes. That is.
In all the days, the first up, Wednesday it is second half. That is 2 p.m.
My lord is fixing on the 12th of February, my lord.
Yes.
I'm so grateful.
Sure. Next. देखिए रखी है
Item number 6.
Sir, I appear for the respondent.
I am for the petitioners, my lord.
Lord, hereby I submitted for the last occasion. Really a project, my lord. The third line from Anahat to Noyati has been installed, my lord. The injunction order granted by this honorable court, my lord. It was a project of 2010. Right? Then the project cost was 384.5 crore, my lord. Now the price has been to a great extent, my lord. Can you hear out the matter, my lord? And let my learned to place his case, my lord. I am ready otherwise. 6 to 19 or another. Kindly take up the matter, my lord. Shobha Vishwas, WPA 505460. All through, my lord.
But there are 14
Prior
matters,
occasion, your
and
lordship's court, my
most
lord.
of the matters are similar. 1, 6 to 9 are the agricultural land, and 10 to 19 are residential.
1 to 9.
6 to 9
6 to 9
are agricultural land,
okay.
and 10 to 19, my lord, residential plot. My lord, sometimes in 2017, in August, September 2017, some persons claiming to be the persons of a contractor engaged by the railway authority started demolishing our structures, our land, and our plantation were destroyed. We raised objection and filed a representation before the railway authority, but they did not consider our representation. So, my lord, we had to file the repetition before this honorable court. After hearing us, this honorable court, my lord, was prima facie satisfied in regard to our ownership over the land and granted and stay order order of status quo. My lord, the fact remains that the land is owned by these petitioners since 1942. There are registered deeds. There are RS Porcha. And we are enjoying the benefits of the land, and we are residing in our residential house at least for last 75 years. My lord, the respondent authority has never been able to produce a single document exhibiting that the said land was acquired at any point of time. On the contrary, my lord, we have annexed the copies of the deeds, sale deeds, RS Porchas, and others with a view to establishing our right over the land. And we are enjoying, as I have already pointed out, my lord, the land, and we are residing there since last 75 to 100 years. Now they are claiming that the land belongs to them, but they have failed to produce a single piece of evidence, a single piece of document showing that the land belongs to railway authority. In any case, my lord, this honorable court directed the railway authority to inquire into the matter, as well as the state government to inquire into the matter and submit an inspection report. That report was submitted unilaterally by the railway authority. Then, my lord, this honorable court has again directed to cause an inspection over the land in dispute jointly by the state authorities, by the railway authorities, in presence of the petitioners. That inspection was done, and a joint inspection report was submitted, my lord. My lord, may kindly come to the joint inspection report. Submitted by the BLLL.
Last year, what happened? Last.
My lord, the joint inspection report reveals
When
that the land belongs to us, and that no piece of the land belongs to the railway authority. And that report was signed by the Senior Assistant Engineer, Eastern Railway, Kachrapara, Senior Section Engineer Works, Eastern Railway, and the Block Land and Land Reforms Officer, Chadda.
what is
After
the date of the
submitting
report?
the submission of this report, my
What
lord,
is the date of the report?
Current report, your document report,
What is the date?
23rd day of June 23, affirmed on.
No. Okay.
second report is, my lord, dated
And the inspection was conducted, my lord, on 14 December 2021.
In person sworn report.
and your lordship will also find a present report, current report on 5th day of January 2024. Pursuant to the directions passed by your lordship's court.
It is an unilateral report, not a joint inspection report.
Pursuant to the direction passed by this honorable.
But that was, in fact, that was an exception to the report
Yes,
submitted.
yes, you have also filed the exception.
Exception to the report submitted by the railway authority and the state authority concurrently. And the said report, it has been held in the said report unanimously that the land belongs to us. No portion of the land belongs to the railway authority. Then, my lord, surprisingly, the respondent authority has contradicted their own report, and they have submitted an exception to the report. The report which was signed by the railway authority. My humble submission before your lordships that this exception is barred by principle of estoppel. Once a report is submitted and the fact is accepted by a party, cannot be disputed subsequently, unless there is a cogent reason supported by the strict evidence that the admission was not correct. Once admitting a fact, how respondent authority, my lord, contradict that said fact? In any event, my lord, I have also submitted an exception in the form of affidavit to the report submitted by the railway authority in 2024. My lord, may kindly come to
Wait. What are the plot numbers involved in the present case? Plot numbers?
plot number, yes, my lord.
What are they?
Plot number 80 and 7. 45. $785. Why plot number?
785.
My lord, may kindly come to paragraph 8 at page 4 of the second report submitted by the railway authority unilaterally. It is stated that the lands are very much required for the project in question, and moreover, since the lands already in possession of the railway authority, it is not at all correct.
Where from are you
Cited
reading?
in
मुश्किल हो
54.
जाती
Affidavit dated, my lord, 5th day of January 2024.
5th January. Exception.
Exception to the report.
Respondent numbers 2, 3, 4, 5.
1, 2, 3, 4.
1, 2, 3, 4. All the railway authorities and Union of India.
This is exception to the report submitted by respondent number 2, 3, 4, 5.
2, 3, 4.
Somnath Biswas has affirmed. This one.
Our I tell you, in the year 2024, your lordships were directed to hold an inspection and give a report, and that was submitted by respondent 1, 2, 3, 4. Against that report, they have filed an exception.
So what is the date of that exception?
Yes, I tell you.
5th day of January 2024.
It. They have filed the exception that is affirmed on your lordship. I tell you, lordship. Our is, my lord. Report is dated 5th day of January 2024. Senior Divisional Engineer, Eastern Railway, Shialda Division.
Madam, may kindly come to paragraph 8 at page 4 of that same report. It is stated that the lands are very much required for the project in question, And moreover, since the land's already in possession of the railway authority since 1954, it is absolutely incorrect. The land was still in possession of us. According to the land plan, the competent authority did not initiate any acquisition proceedings in respect of those lands. Since presently the petitioners are allegedly claiming ownership of those lands on the basis of some alleged deed of purchase and LR records, the petitioners are at liberty to put forward their claim before the competent authority for getting compensation by establishing their right, title, and interest in respect of those lands, because it is settled law that the record of right is a document of possession and not a document of title. I fully agree with the submission made by the railway authority. My lord, they are, in one hand, they are telling that the land is in their possession. In other hand, they are telling that we can claim compensation. The fact remains that the land is still owned by us. The land was being cultivated by us. We are residing at the house. Still, we are residing at the house constructed on the disputed plot. Now they are admitting that we can claim compensation. And my lord, when a welfare project is taken by a government, either it is the state government or the union government, as the bona fide citizens, we are not objecting to this development. But as per settled procedure and principle of law, the state government or the central government are required to make compensation. There is a procedure for acquisition of the land. We are ready to offer our land, even our domestic house, provided they settle with our claim according to law.
Okay.
My lord, may kindly come to our exception to the affidavit submitted by the railway authority. My lord, in March 24,
Yes.
in fact, my lord, the land which is in dispute now was sold by a court order under Order 21 of Rule 94, long back in 1942. My lord, may kindly come to page 11, that is 11A. 11 is very illegible. Where
Page?
the Court of Munsifs, under Order 21 Rule 94,
Which page?
11A, my lord,
Yes.
is typed. রানাঘাটের মুন্সিফ আদালত সন 1942 সালের 1400 নম্বর খাংবাড়ি মোকদ্দমা শ্রী বনবিহারী মণ্ডল, পিতা নিবারণচন্দ্র মণ্ডল, মোকাম কাছারি ও থানা বীজপুর, জেলা 24 পরগনা, ডিক্রিদার বনাম মৃত অটল বিহারী পালের ওয়ারিসান ভ্রাতা ও স্বয়ং মৃত অনন্ত বিহারী পালের ওয়ারিস লক্ষ্মীকান্ত পাল, ওই মৃতের ওয়ারিস ভ্রাতা স্বয়ং মৃত বিপিন বিহারী পালের ওয়ারিস কন্যা পঞ্চাননী দাসী, and মৃত রোহিণীকান্ত বিশ্বাস, সাং সগুনা থানা চাকদাহ 6, ওই মৃতের ওয়ারিস কন্যা হরিবালা দাসী, ঈশ্বর সুকু ঘোষ, সাং কাঠুরপাড়া থানা, জেলা নদিয়া ইত্যাদি। দেনদার এত দ্বারা সার্টিফিকেট দেওয়া যাইতেছে যে অত্র আদালত কর্তৃক 2/6/42 তারিখে নিষ্পাদিত সন 1942 সালের খাজনা, I presume that it is বকেয়া খাজনা, it was so illegible, বকেয়া খাজনা এই মোকদ্দমার ডিগ্রি জারি সন 1942 সালের 9/9 তারিখে নিলামে দেনদারের নিম্ন তফসিলে বর্ণিত বাকি পড়া সম্পত্তি 1 নম্বর লাট সাব্যস্ত মূল্য 395 টাকায় শ্রী সুরেন্দ্রনাথ ঘোষ, সগুনা থানা চাকদহ, জেলা নদিয়া খরিদ করায় এবং 30 দিনের মধ্যে উক্ত নিলাম রদরহিতের কোনো দরখাস্ত বা হুকুম না হওয়ায় উক্ত শ্রী সুরেন্দ্রনাথ ঘোষ উক্ত সম্পত্তির নিলাম খরিদ্দার অবধারিত হয়েছেন এবং উক্ত নিলাম এই আদালত কর্তৃক 11/21/11/42 তারিখে রীতিমতো বহাল হইয়াছেন। So my lord, it is a conclusive proof by a sale of deed which was executed by the order of by the learned court, that the particular land, plots of land, belong to Bonobihari Mondol. Then some Surendranath Ghosh purchased that lands from Bonobihari Ghosh through court. Then Surendranath Ghosh sold this land to some persons who are the ancestors of these present petitioners. My lord, may I kindly come to page 4, subparagraph C. After purchase of the land as mentioned herein above, said Shailendranath Bishwas. Shailendranath Bishwas has purchased the land from the other persons. Then my lord, actually my lord, may kindly come to subparagraph B at page 3. Be it pertinent to mention here that said property was ultimately inherited by one Panchanan Ghosh, and after death of Panchanan Ghosh, the property was sold to Shailendranath Bishwas. Shailendranath Bishwas is the husband of the present petitioner, Shobha Bishwas. Shailendranath Bishwas, being husband of the petitioner number 1 and father of petitioners number 2 and 3 herein, by the widow of minor son of deceased Panchanan Ghosh, through a deed of conveyance registered at the office of joint sub-register at Ranaghat at Chagda on 23rd May 1952, and was entered at pages 95 to 97 of book number 1, volume number 23 for the year 1952. A copy of this edit that is enclosed in as R2, my lord. Page 13 and type paste, my lord, 13A.
Panchanan is the son of Surendra.
My lord.
Okay.
গৃহীতা শ্রী শৈলেন্দ্রনাথ বিশ্বাস, পিতা মৃত রোহিণীকান্ত বিশ্বাস, জাতি হিন্দু, পেশা কৃষিকার্য, so and so. দাতা শিবপদ ঘোষ, পিতা মৃত পঞ্চানন ঘোষ, পক্ষে অবিভাবিকা মাতা ও স্বয়ং ননিবালা ঘোষ, স্বামী মৃত পঞ্চানন। তোমার একটা পেজ 15A, কস্য রায়তি স্থিতিবান সত্ত্বে জমি জমা সাব বিক্রয় কবলাপত্র মিদং কার্যাঞ্চাকে, আমাদের নিম্ন তপশিল উক্ত জমি যাহা শ্রী পঞ্চানন ঘোষ 27/2/48 তারিখে 1739 নম্বর রেজিস্ট্রারিকৃত বিক্রয় কবলা মূলে খরিদ করিয়া সত্যবান ও দখলিকার থাকিয়া উক্ত পঞ্চানন ঘোষ মারা গেলে তাহার তজ্জ সম্পত্তিতে আমার নাবালকগণ সহ ওয়ারিশ বটে। এইক্ষণে উক্ত নাবালকগণের ভরণ পোষণ ও উপযুক্ত শিক্ষা দীক্ষার জন্য এবং আমার অন্যান্য জমি চাষ করার জন্য নগদ টাকার বিশেষ প্রয়োজন বশত উক্ত জমি বিক্রয় করা ছাড়া অন্য কোনো উপায়ে টাকা জোগাড় করা অসম্ভব বিধায় নিম্ন তপশিল ভুক্ত জমি 6.63 একর 6.63 শতক বিক্রয়ের জন্য প্রকাশ্য ঘোষণা দেওয়ায় আপনি জানিতে পারিয়া উক্ত জমি বাজার অপেক্ষা সর্বোচ্চ মূল্যে 1000 টাকা দিতে স্বীকৃত থাকায় আমরা আপনার নিকট হইতে উক্ত জমির বাবদ লিখিত টাকা পেয়াইয়া এই সাব বিক্রয় কবলা আপনাকে সম্পাদন করিয়া দিয়া স্বীকার ও অঙ্গীকার করিতেছি যে আমাদের উক্ত বিকৃত সম্পত্তিতে যে সকল সত্ত্ব স্বামিত্ব ছিল তাহা অধ্যকার সম্পাদিত কবলা দ্বারা লোপ পাইয়া আপনাকে বর্তাইল ও আপনি নিজ সম্পত্তিতে আমাদের সত্যবান হইয়া মালেক সেরেস্তায় খাজানা দিয়ে আদায় দিয়া আমাদের নামের পরিবর্তে আপনার নিজ নাম পত্তন করিয়া পরম সুখে পুত্র পৌত্রাদি ওয়ারিশগণ ক্রমে দান বিক্রয় হস্তান্তর ইত্যাদি প্রকার কায়েমী কার্য দ্বারা ভোগ দখল করিতে থাকুন, তাতে আমরা বা আমাদের ওয়ারিশগণ কোনো প্রকার দাবি দাওয়া করিতে পারিবে না। যদি উক্ত দলিলের নাবালকগণ ভবিষ্যতে সাবালক হইয়া উক্ত সম্পত্তিতে দাবি দাওয়া করে বা আমরা করাই বা আপনাকে বেদখল করি বা করাবার চেষ্টা করি, তাহা হইলে আমরা যাবতীয় প্রকার ক্ষতিপূরণ দিতে বাধ্য থাকিব ও রহিলাম। যদি না দেই তাহলে আইন সামনে আসিবে। উক্ত সম্পত্তি আমরা ইতিপূর্বে কোথাও ঋণে আবদ্ধ বা দায়বদ্ধতা করি নাই ও করা হয় নাই। যদি প্রকাশ পায় যে আপনার সত্ত্ব দখলের কোনো বাধা হয় বা বেদখল হন, তা হইলে আইনত দণ্ডনীয় ও ক্ষতিপূরণে দায়ী হইব ও রহিব। এতদর্থে সুস্থ শরীরে এই সাপ বিক্রয় কবলা আমি সম্পত্তি বরাবর মূল্যে টাকা পাইয়া সম্পাদন করিয়া দিলাম। ইতি সন 1369, 8ই জ্যৈষ্ঠ, ইংরাজি 22/5/52।
Yes.
So, my lord, it is clear. It is clear as crystal that since 1942, the lands are owned by the private person, not by the railway authority. Till date, the railway authority has not been able to produce a single document exhibiting that the land was ever acquisitioned. Now they are trying to grab our land for civility, which they can't. And my lord, as I have already submitted, that the respondent authority has candidly admitted that the land belongs to us and they are ready to get compensation, provided we can claim compensation. We should claim compensation. But my lord, the law is different. When state is required to use a private land, they will have to follow a procedure for acquisition of land. They will first notify that this land will be required for such and such purpose. Then they will offer the compensation to the affected persons. And then they can acquire the land. And my lord, may kindly come to page 30. The Gas Authority of India Limited wanted to use that land for laying their gas pipes under the land. It is a limited use for limited purpose. They can cultivate their land, but there are some restrictions that they will not be able to erect any building over the land, or they will not plant big trees. But they can plant, they can plow the land and they can harvest paddy and others, etc., small plants. And they have already used that land and have offered compensation. They have paid compensation for the land, which the other department of the government is claiming that it is their land. Mechanic come to page 30, actually page 31. It is a copy of the Gazette issued by the government of India. Excuse me. My lord, may kindly come to page 32. That is serial number 7980. Survey number in Soguna Mauja. Belongs to the petitioners.
Page 30. 32.
31, 32, my lord. 31 is the copy of the Gazette, and 32, the land which was utilized, which was, in fact, which was partially acquired by the Gas Authority of India Limited. And they have already paid the compensation. And I have stated this fact, my lord, in my exception at page 4, subparagraph E.
This is agricultural land.
It's agricultural land. They are laying pipes through the agricultural land, since they cannot lay pipe below the residential plot.
So underneath the agricultural land, the pipelines have been already laid,
Already they have been installed.
and you are carrying on agricultural activities over that land.
No, my lord. Due to order of the status quo, I am not in a position to cultivate the land.
Okay.
And for this reason only, I have asked for compensation. And my lord, they have changed the nature of the land also. They have filled our agricultural land with sands, pebbles, stone chips, etc. for laying the railway track. And we are not in a position to cultivate the land. We are losing our livelihood day by day.
But then what will happen to the underground pipeline that has been laid by the petroleum
They have
gas company?
laid the pipes. Already they have laid the pipes.
You get
But
a,
we can cultivate the land in spite of laying the pipes. Because pipes
where
is
is
below, I think, 10
where
feet.
is the document? Where is the document of acquisition and payment of compensation by this?
31, 32, my lord. 35. This is the compensation admitted by the Gas Authority of India Limited.
35.
35. মোট ক্ষতিপূরণের পরিমাণ 1,98,771 টাকা।
35 of which writ
But
petition?
my exception.
No, you should have taken. That was actually fine. Straight বলছি আমাদের চলে গেছে হ্যাঁ আমি কমপ্লিট
Then same land will be again acquired by the railways. How?
My lord, railway has not acquired that.
If a direction is given to the railways, how can the railways acquire the land which has already been acquired by the petroleum as per you?
It was partially acquired. They have not fully acquired the land. They are
Which one?
utilizing the land.
No. In this case, the entire land you have said that the railways are in possession, or they are not in possession?
No, not in possession.
You are in possession.
I have been.
So what is your prayer in the writ petition?
My lord,
What is your prayer in the writ petition?
where is the writ petition? Either to acquire the land and pay our compensation.
Now you say that you have given it to the gas company, petroleum
My lord,
company.
it is subsequently. My lord, may kindly come to the gazette notification. It is after filing the writ petition.
Now that land which has been already
21.
acquired by the petroleum company, that cannot be taken up by the railways. If at all there is a direction by this court
And that-
that railway will initiate a proceedings for payment of compensation, then that land has to be left over.
My
What is the
lord,
portion of
in
that?
that event, the railway authority may take up the matter of the Gas Authority of India Limited, whether they will be able to lay the railway tracks over the land under which the gas pipe is running. I have submitted this document only with a view to prove my right over the land. Gas Authority of India Limited has followed the legal course of action, and they have taken the legal course of action. But Railway Authority has tried to forcibly grab my personal land without offering any compensation.
But then how could this be a subject matter of a acquisition proceedings of which a writ petition has already been filed before the court?
Well, this is not acquisition proceedings.
Petroleum has taken a acquisition proceedings by which the compensation has been paid to you.
Yes, my lord.
So that portion of the land was already pending before this court. You have made a prayer.
No, my lord. I am not
What no?
objecting that of acquisition by the Gas Authority of India Limited.
It is not a matter of objection. You have filed a writ petition wherein the entire land has plot number 785 is in consideration before this court. Whether the railway will proceed with the acquisition of the entire land. Huh? So how come this proceedings has been initiated by them to lay down the pipeline? And it was never brought to the notice of the Petroleum Authority that that particular land is in proceedings before this court. And there is a status quo order passed in this.
That was not brought.
Then
That was not brought.
you received the compensation without informing the authority
No,
that
my
this
lord.
is the position.
No, my lord. Gas Authority of India Limited is aware of the fact that the deed petition has been filed, but they have relied on the document submitted by us that the land belongs to us. And this gas line, the laying of gas pipes concerns the plot number 80 in Shoguna Mauja. But the other plots which are situated in Madanpur Mauja have not been affected. The Gas Authority of India has not taken any action or has not resorted to any course of action in respect of that plots of land in Madanpur Mauja, since they are the residential plots.
LR 80 is subject matter of this particular writ petition.
My lord.
Then
Agricultural land.
what is the total measurement of LR 80? Yeah.
Your lordship will get subject to correction.
32 of the exception.
2 of the writ petition.
2.5 acres. And nearly 2.5 acres.
2.5.
Showing the document. এখন আমি ঠিক দেখাচ্ছি না। It's 32. Read. And it has got it, my lord. Your lordship will get plot number slash dark number 80.4785. Now your lordship total land 3.22 and the share 2.58. Has your lordship got it?
Then 1.41, they are 0.37. These are the 4 agricultural landholders. Somnath Bishwas, Anukumar Pal, Topon Pal, and Kullani Pramanik.
কি করেছে?
3.84 acre total petition's land. Here about 11 bighas. House.
By feet. How much has been acquired by the gas company in plot number 80?
Page 32. Third column. First column, District Nadia, Tahsil Chagda, Village Soguna 80. And then, my lord, serial numbers, the plot numbers, that is survey number 79 and 80. It is a part of the gazette notification.
A 15.67 square meter.
My lord.
So what is in
My lord, this is
acre?
the partial utilization. They are not acquiring the whole land.
Hmm.
The entire area of the lot is not being acquired by them. In fact, they are utilizing our land without changing the status of the land. Since the pipe will be laid below the land,
Sir, instead of this,
status of the land is not being changed.
6 4
Well, I have the instruction that the gas pipe has been laid under 40 feet below the land. And the gas line has run below the rail line also, railway track.
below the railway track also.
Yes, my lord. Since it is running below 40 feet from the surface.
Achha.
Railway track is, my lord, is existing just beside our land. And Gas Authority of India has laid the pipe below the railway track also. By excavating land below 40 feet from the surface of the land.
Yes. Next.
So, madam, my submission that we are not averse to the railway project. We are ready to offer our land. Since we have already offered it for partial use of the land by the gas authority, subject to the current condition that they will have to pay our compensation for loss of income due to non-cultivation of the land in question. And if they require the land, they have to acquire the land in accordance with the law. And they will have to pay us the compensation as per settled principles of law and the formula followed by the railway authority for acquiring private land. And I have already stated in my writ petition that we are ready to offer the land for laying the railway tracks, and it will benefit us also.
Where is that?
Contrary, the case made out in the writ petition is contrary to the submission made by this my land.
No, which paragraph he has stated?
Also correcting my learned friend, madam, I will also kindly peruse the prayer of the writ petition. Respondent agent remove the demarcated portion. But your lordship kindly record the statement made by the learned friend that they are ready to give the land in the event they are given compensation. At least that portion may be recorded. Railway do not ready. And the project of 2010 of 384.5 crore. Now it has practically it has been come to double. If they can produce before the appropriate authority their land after adjudication, railway must give it.
Who will initiate the proceedings if they are ready? And
Complete one, I will do it.
no, we first decide on this issue. If they are ready and willing to offer their land for the project of the railways,
That is not in the writ petition.
Anyway, if it is not there, he submits that they will offer their land.
Yes.
He will make a comprehensive representation before the competent authority, who will adjudicate the matter.
And I have
pass the
received I have currently I have received a written instruction to that effect from the authority. And only thing, they are to, this is a disputed, the point raised by my learned friend is a disputed question of fact. Firstly, cannot be decided in the writ petition. My learned friend, by showing that this is only relying on the LR Khotian and RS record of right, they are claiming. But according to the railway authority, the railway plan of 1954, my lord, I have annexed that. It shows that it is the land of the railway. And therefore, since this is a land of the railway, railway did not issue any notification or gazette notification for acquisition of the said land. Even then, my lord, since the railway has already suffered a loss and the public at large will suffer in the event, my lord, it is not materialized, the project will abandon, it will go back. Never it will be. That is why I have, before your lordship, my lord, I have received the instruction and I am showing to your lordship. I have a copy, giving to your lordship. This has given to me, your lordship kindly produce it once. This will solve the problem, my lord. As per, may I place it, my lord? As per Honorable High Court's order quoted under reference, the 14 number pending cases will be heard on 13 January, and this office has following updates to share with you. But this is given to me. The railway holds land plans signed by the state authorities older than the cadastral survey document. The railway maintained its land boundary according to the railway land plan. That is there, my lord. The original is with us. In the instant 14 numbers of court cases, the issue of land dispute is under continuous detailed exercise of ascertaining railway land with state government authority. At this point of time, the railway has no objection in acquiring the land from the concerned if needed for completing the project of third line National Highway RHA section. On several persuasion with the state government authority, it has now been informed by Special Secretary to the government of West Bengal by memo number such and such. The additional district magistrate LA Nodia has been nominated as competent authority for land acquisition under the Railways Act 2008 for acquisition of 8 acres. My lord, it may increase, it may decrease. My lord, they have tentatively in Nodia district, West Bengal, in connection with the Noihati Ranaghat third line as a special railway project. As such, appropriate argument may be the before Honorable Court can produce third line and for the sake of the national interest immediately. Well, this is the, and my lord, next page, perhaps your lordship will take. Now, this is, my lord, the Special Secretary to the Government of West Bengal has written to the Chief Engineer, my lord. Has your lordship got it, my lord? There it has been nomination of CALA for land acquisition in respect of the Noyati Ranaghat third line as a special project for acquisition of such and such land. With reference to the above mentioned subject, I am directed to convey that the additional district magistrate LA Nodia is nominated as competent authority for the acquisition of the such and such land as special railway project. As acquisition of land will be constant based on no forceful acquisition when necessary gazette notification for the appointment may be now be published. And has your lordship got it? So, my lord, there is no dispute if they prove before the competent authority. Well, High Court cannot decide which is the agricultural land, which is the Sali land, and compensation varies from land to land. If at all it belongs to them, that they will prove before the appropriate authority. But the injunction order should be, my lord, vacated and giving liberty to the writ petitioner to approach before the authority. They will decide and produce accordingly. This is my concrete submission to your lordship.
My lord, I have already placed
And your lordship
various documents
find
to
from
prove that the ownership belongs to us.
Find from the prayer made in the return, they wanted return of the land. And I can show from your lordship, my lord, they are not in possession. That is statement, my lord, I can show to your lordship 1, 2, 3 statement from the writ petition. And your lordship kindly produce the writ petition. Paragraph 1, once. As your lordship got it, writ petition. Paragraph 1. The aforesaid writ petition has been filed by inter alia direction to remove the demarcating post. I tell you, paragraph 1, I am placing. This is Shobha Vishwas. Yes. Paragraph 2, your lordship, the petitioner says that they have inherited agricultural plot of land, number such and such. Your lordship will find my total land has been 2.5 acres after the death of Soilendranath Bishwas being the husband. Now your lordship will get, my lord, paragraph 3, how they have inherited. Now your lordship kindly peruse paragraph 4, that the petitioner states that Soilendranath Bishwas had been cultivating the land and growing varieties of agricultural crops. His cauliflower, cabbage, etc., and are cultivating the land in a similar way, inasmuch as the said cultivation has been main source of income. Now, paragraph 5, that the petitioner states that the railway authority, in respect of the past, has taken decision to set up third railway track from Noihati to Krishnanagar through Madanpur, similarly, in addition to the existing double line. Now, my lord will skip up with that portion. My lord will peruse, my lord, page 7, first paragraph. In view of the facts stated here in it can safely presume that the then railway authority, while acquiring the land long ago, had reasonably contemplated the future need of expansion of railway track. But due to the longitude, languid attitude on the part of some railway officials, some unscrupulous persons have forcibly taken over the land, over which the railway authority has absolute title. One has seen this absolute title forcibly taken over. They are saying that they are in possession.
It is the other side of our land.
And has
That
used
land
the said land.
does not belong to us.
Don't interrupt. I have not interrupted.
And that particular land is owned and possessed by the railway authority. But they have not taken any action against the unscrupulous and unauthorized construction over the railway land. Now they are trying to grab our land.
Please do not interrupt. Now your lordship kindly peruse paragraph 8. Surprisingly enough, in July, August 2016, a few persons claiming themselves to be the workers of the contractors appointed by the railway authority stormed into the land and started demolishing the fencing erected by the petitioners to save their crops from the cattle and intruders, in as much as they started destroying the agricultural field using mechanical devices without any prior information and or notices to the petitioner. This is their manner. Therefore, they have come approach before this court. Next paragraph, that the petitioner states that immediate thereafter they had produced documentary evidence. I had kindly skip over the last but one line. On the contrary, they also remarked that they did not rely upon the document issued by the state government. Inter alia stated that the piece of land belonged to the railway department, albeit had failed to produce any prepared documents in support of their claims. Next, paragraph 10. It is very pertinent to mention here that since the date of purchase of the landed property through registered sale deed of the year 1952, the petitioners are enjoying the peaceful right and encumbrances free title over the said property, inasmuch the petitioners are utilizing the said land for cultivation for the couples of decades and have never confronted with any impediment regarding the title ownership of the property. Now, your lordship kindly peruse. Honor. Just a minute. Paragraph 22, your lordship kindly peruse. It is pertinent to mention here that requisition and acquisition of land, even for public purpose, has posed a threat to the public body and railway. board, after realizing gravity of the situation, had issued a circular number such and such, wherein it has been categorically mentioned that project should be implemented in such a manner so as to cause minimum acquisition of land, particularly the agricultural land, and dislocation of landowners, inasmuch as it has been further contended therein that the project, other than the new lines, should review the proposed alignment, construction, methodology to ensure that the construction is contained with existing railway boundary to the extent possible. This is according to us, we have annexed the railway boundary plan. This is within the railway boundary. Well, I have the original plan with me, my lord. I can hand over to your lordship. And the ultimate prayer, my lord, your lordship will get from the petition that a read in the prayer, a read in the nature of mandamus, commanding the respondent, each of them, their agents, servants, and the subordinate, to remove the demarcating post from the land of the petitioners and to return the forcible occupied portion of land to the petitioner after resorting previous character of the land. Well, now they are submitting otherwise. And under the Railway Act, the railway can take, my lord, and railway will take in accordance with law. Railway do not want to deprive, my lord, any citizen of India from their own land. And the only thing the competent authority will decide, and compensation will be given accordingly to them, having regard to the nature of the land. Well, the only thing I am beseeching your lordship, kindly vacate the interim order and give liberty to the petitioners to approach the appropriate authority, my lord, so that the project can be completed.
Okay. If the railway authority is in requirement of the land, I have the instruction that the petitioners are ready to give their lands to the railway authority.
So that should
So,
be decided.
so they should initiate the acquisition process.
Character of the land, agricultural land or shally land, my lord,
That will be decided by the LA
before
collector.
that, it will be decided whether the title belongs to them. Well, because they are relying on the title, well, RS record of right. The railway is having the record, my lord, of prior to that railway.
Yes. CS records.
CS record, and prior to that, my lord. Well, how they have
My lord,
been,
they have not produced any CS
that will be
record.
decided by the all points be kept open. All points should be kept open, my lord. Only thing, my lord, project should be allowed. If under the law they are entitled, they will get it. No issue, my lord.
They will continue with the project after paying the compensation.
After paying, my lord, the proceeding will continue, my lord.
My lord,
In that event, again the project will be abandoned. It will go back.
They should first
Tell me one thing, that within which period of time this competent authority is going to decide the issue.
But
So this cannot be.
This is for the competent authority has been appointed under the Railways Act. The Railways Act provides.
The railway authority will have to first initiate a acquisition proceedings. Acquisition process is to be started through LA collector, who is the designated authority by the railway authority. And in any state, it is the duty of the LA collector to determine the nature of the land, to determine the quantum of the compensation according to the rules
appointed under this act. It is not within the competence of the railway authority. It is the state government, my lord.
I have said so. That is the LA collector.
And not the specific authority has been decided by under the act. Amendment Act of 1908. Yes, 2008. It has been decided that who will be the competent authority, and they will decide. But this is not up to the railway authority. It is the appropriate authority that they will decide it.
Where is it?
And your lordship kindly produce this act. This has been the authority has been appointed under this act. So, they are the authority, but only thing they will get compensation or not, whether the land belongs to them or not. That will be decided. Even if it is decided, they will get compensation according to the provisions of the act.
And whether the lands belong to us will be decided by this honorable court on the basis of the evidence produced by me.
This is a disputed question of fact that cannot be decided by this honorable court. And in every proceeding, land acquisition proceeding, there the collector is there. The High Court is not authority to decide the title of the property. Their case is their land has been practically encroached. Encroachment is a civil dispute that should go before the civil court. And I am not harping on that. But I am submitting, my lord, that the authority has been appointed, having regard to the facts and sufferance of the railway authority. Your lordship relegate give the petitioner to approach before that authority, let them decide, and your lordship can kindly vacate the identity model so that we can proceed with the project.
My lord, when there is a disputed
Wait,
question of
wait.
fact,
Wait.
the fact is to be decided on the basis of the evidence
Calcutta?
produced by the parties. It is a settled principle of law. So far, the railway authority has not been able to produce any documents. They even accept a sketch plan in support of their claim. If the land,
And I have annexed.
if the land does
report, my
belong
lord,
to
the
the
Xerox
railway
copy,
authority,
and I have annexed the
they
report.
will have to
Xerox copy.
produce
I have handed over
the
the original
acquisition
copy,
order.
and I can hand over the original copy, my lord.
They will have to produce the acquisition order.
Taken
When the land was acquisition, how much compensation was paid to the landowners at that point of time? No such document is there. Even the joint inspection report participated by the LA collector, representative of the LA collector, clearly exhibits.
অ্যাক্টের পুরোটা নেই বলো
Pardon, my lord.
অন্য একটা অ্যাক্ট give another copy of the act is incomplete, the pages are not there.
This is, my lord. This is, my lord. There is the Railways Act, my lord, 89. In the Railway Act, my lord, a clause there has been some amendment, and this is the complete amended act. And your lordship will give. May I place this?
Give me the provision wherein the competent authority can
Yes, sir.
decide the issue.
Yes.
Then liberty will be given to them to approach,
And I am sure.
and you have to dispose the matter within a particular period of time. Otherwise, keeping it for inordinate time, and also the grievance of the petitioner will not be addressed, and will continue the project. That is not. You did tell me within which period the competent authority
Your
decide.
lordship kindly produce.
And if they are willing to offer the land, if they can show their title.
According to the railway, this is not the land of the petitioner. That is, there is the dispute lies there, man. Your lordship kindly.
No, you have submitted that the competent authority will decide. You just tell me within which period he will decide.
Madam, the competent
that is
authority has
provided in the
already
act itself.
decided,
Where it is.
has already
Section?
decided through the
Section?
joint inspection report
Man, your lordship
that the
kindly.
land belongs to us.
Man, your lordship, an act to provide further amend the Railways Act 1989. Has your lordship got it at the top?
Yes.
It enacted in the Parliament in the 59th year of the Republic of India as follows. My short title. Has your lordship got it, my lord? Short title and commencement. This act may be called Railway Amendment Act 2008. It shall be deemed to have come into force on the 31st day of January 2008. Now, my lord, next part. Amendment of Section 2. Amendment of Section 2. In Section 2 of the Railways Act, hereinafter refers to as the Principal Act. After Clause 7, your lordship, the Clause 7, there is the following clause shall be inserted, namely 7A, competent authority means any person authorized by the central government by notification to perform the function of the competent authority for such area as may be specified in the notification. That is the competent authority. On that, my lord, the competent authority has been appointed. On that, the competent authority has been appointed. Now, my lord, 29A has been amended. My lord, a person interested includes all persons claiming an interest in compensation to be made on account of the acquisition of land under this act. Everything is there, my lord. They will follow the provisions of this act and will decide.
Which is the Railways Act 2008 is with you?
2008. That
prior to amendment.
Prior to amendment, my lord, this act is with me.
Give that.
There is, my lord, marking in one person. In that Act, clause 7, clause 29A, and other clauses has been amended. That is the amended Act of 2008. I have made tick mark against clause 7. The 7A is not there. Only for the purpose of railway project, this amendment Act of 2008 has been formulated. For the limited purpose for completion of the project of a railway throughout India. Your Lordship will get it from the power to take possession. That what part, my lord.
Section?
And the Act 2008, your Lordship will get, my lord, power to take possession 20.
Power to take it, 20I.
20I. Power to take where any land has vested in the central government under subsection 2 of section 20E and the amount determined by the company under section 20A with respect to such land has been deposited under subsection 1. This is my with the competent authority by central government. The competent authority may by notice in writing direct the owner as well as other person who may be in possession of such land to surrender or delivery of possession thereof to the competent authority or any person duly authorized on this behalf within a period of 60 days. But if it is vested, according to the railway, in this case, this is not the land of the petitioner. The question of vesting does not arise. Even then, my lord, the authority has been, competent authority has been appointed. They will decide the issue and they will adjudicate.
Within which period? This 60 days? 2 months they will adjudicate this matter? What is the timeline?
But I have to manage once. In 60 days, when the amount has been deposited, admittedly land of the party has been taken away. This is not the case, my lord, that admittedly the land has not been taken away, of the petitioner's land has been taken away by the railway. These little differences here, my lord. Your lordship once peruse my report of the engineer according to my own way. May I place the report? Your lordship will get it. May I place the report once? That dated, my lord, 5th January 2024. For your lordship's kind satisfaction. My lord has got it. First paragraph is, my lord, I see Amit Kumar son of, this will not, I am the, paragraph 1, I am the senior divisional engineer, Eastern Railway. In terms of the direction, paragraph 2 onwards, my lord, I am placing. In terms of the direction passed by the Honorable Court, the Railway Authority again held inspection and surveyed the land in question, which are subject matter of the instant writ petition, along with other several pending writ petitions. That for the purpose of holding the survey work, the surveyor also considered the railway plan, land plan dated 28 December 1954, certified by the Secretary of the State Government, wherefrom it reveals as follows. The railway is relying on this. I have the, my lord, the original copy that has been drawn, that all the B land shown in the plan resumed by the government, with the exception of the portion colored red marked A under construction and engineers number 308 dated 16 February 1871, Board of Revenue by drawing number such and such, wherein certification has been made by the Assistant Secretary, Government of West Bengal on 28 December 1954 as 2 copy. During inspection, it is seen that the railway boundary pillars already exist, covers the land also since long. This is the main case of the railway authority. That is why no notification. Then, my lord, the deponent craves leave to refer the aforesaid land plan of the year 1954 at the time of hearing. Now, paragraph 4. Well, I have given the Xerox. I have the original. I am handing over to your lordship. And there is another broadsheet is there. This is the green line. Your lordship will not understand from the Xerox that
No, this is legible. This copy?
otherwise legible, but there we have stated, my lord, about the green line, blue line. That will lordship, and let it be kept to your lordship. Your lordship will find, well, the land, one of the land of the petitioner is within the railway boundary.
Green is the boundary.
Within the railway, my lord.
Green line is the boundary.
My lord, the boundary line is the, my lord. Green line to the boundary. Railway boundary. Yes. Well, green is the railway boundary. My lord, notes are there. Your lordship will get. There it has been written. Railway land boundary as per plan and A land shown in the magenta. My lord has got it. But your lordship will get plot number 80 is within the railway boundary. Just one. That is my case of the railway, my lord. LR record or RS record cannot be, my lord, relied on for the purpose of giving compensation. And according to the petitioner's own admission, my lord, the land has been taken away by the railway. Not in their possession. They are orally submitting before the lordship that this is their in possession, they are residing there. This is not correct.
My
This is a disputed question of fact.
lord, it was never my submission that the land is not in possession of us. I have all along submitted that the land is owned and possessed by me. I was cultivating the land till the land was destroyed. The nature of the land was destroyed by the railway authority in 2017.
So this is the first writ petitioner, Shobha Vishwas.
Yes.
17.
Her land is within green
Green
boundary. Now the next one is
Just development.
Mantula Devi.
Yes. Your lordship will find, my lord, case number 129 is there. And there are other. Shobha Vishwasটা আছে. And the plot numbers are written in the within the green line. My lord will get it, my lord.
What is the second writ petition?
Second. Then I have prepared myself on the basis of second টা কি আছে দেখো. Just a minute. আমার কাছে এটাই আছে. দেখো মানে this cannot be decided by this Honorable High Court. High Court 6-2. এটা তো আমার কাছে দেখা যাচ্ছে. ওইখান থেকে দেখ. না 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 এক মিনিট প্ল্যানটা বার কর. Anupam. 780. And second petition is, your lordship will, I have got it, my lord. Left hand side, case number 1234. My lord has got it. Left hand side, case number 1234.
1 to the yes.
4 WP 5462 Bhanukumar Pal.
Yes.
Now your lordship will get it. Plot number 785. Just above that.
Okay. Then this application is Shobha Vishwas.
The application I placed before your lordship is Shobha Vishwas. That will, my lord, in the middle. LR plot number 80.
Okay.
Very portion, case number 5460.
Shubhodra Pal.
Third one. Shubhodra Pal. Shubhodra Pal, my lord, left hand side, petition number, serial number 2. Shubhodra Pal. Plot number. This also 785, plot number, subject to correction.
Kollani Pramanik.
Serial number 1.
Serial number 1.
One of the left hand side. What number? This also 785. 1, 2, 3, 4 are all 785.
Sure.
They are claiming different shares in respect of the plot in question.
Now come to the right hand corner. The case numbers, there is of Chitra Chakraborty. Their land is 1690. This is not part of the railways property.
This is outside.
Outside.
Let us.
Yes, sir. This plot of Chitra Chakraborty, what is your submissions? This is not been disputed by the railways.
No, my lord.
And what is your grievance with regard to this credit petition?
And if they want to acquire the land, then they will give the compensation.
That will be the total order.
My lord, the Mohama prepared by the LA collector and a land reform department, which has been annexed at page 22 of the deed petition, tells different thing.
And subject to correction, my lord, your lordship will find it. It is case number 1 of Chitta Chakraborty, my lord has got it.
Yes.
My lord, perhaps he has also land. Yes, short number 1691. Right hand top, plot number 1691, Madanpur.
Yes, yes, yes.
That is why. One is inside, one is outside. Let it be kept with your lordship. But we have
You just
also
tell me the timeline within which this can be disposed of by the competent authority.
that even I have to take instruction.
Okay.
Anand has heard at length, my lord,
Take instruction, inform this court. In the
By
course
which
of the day, can you inform or I place it tomorrow?
this has to be, my lord, communicated with the state government because the ADMLR is the competent authority, not the railway. And we have to talk to the railway, the ADMLR and
Come back tomorrow.
and
Then?
with this Ganga Sagar is going on, the officers are not having.
No, I just want to know what is the period within which the competent authority can dispose of the applications of the petitioners.
I follow. I follow. And that is why, my lord, the railway authority will talk to the state government officers, the appropriate officer. They may not be available. That is why, my lord, come before your lordship and again I ask for adjournment. Kindly keep this matter 1 week after, my lord.
1 week after, I will not be in Calcutta because there will be circuit bench. So it will be placed in February.
Then on Thursday, at Ganga Sagar, my lord,
I shall try, my lord, in that even having regard to the issue involved, my lord, I shall try, my lord.
Since both the
In
sides,
beginning
he
of
also
the-
says that he will approach. So you tell me the
Okay,
timeline
fine.
within which his application may be disposed of. After that, he will continue.
And,
First, decide this issue.
and lordship, kindly keep it. I shall try my best, my lord. If I cannot, my lord, I shall ask you.
When? Wednesday?
Thursday, my lord.
First. Mr. So learned advocate appearing for the petitioner submits that the petitioners are the owners of the land in question and their names have been duly recorded in the
Record the observation made by my learned friend and my
record of rights. The petitioners are willing to offer their land to the railways for the project of a railway line in between Kalyani and Madanpur. Is it correct? Kalyani and Madanpur?
My lord.
Kalyani and Madanpur?
Noihati Ranaghat third line.
Noihati or Kedin? Noihati, Ranaghat, third line.
Third line.
Third line.
Extension.
Extension of Noihati, Ranaghat, third line.
Up to Kalyani Mile it has been completed.
Third line. The Railways Authority have not initiated any acquisition proceedings for acquisition of the land of the petitioners, nor has paid any compensation. Stop. The petitioners are in possession of the land in question.
And because of the fact why you have not initiated?
I record your submissions also. কি বললাম? Possession. He seeks for appropriate orders. On the contrary, Mr. So-and-so, learned advocate appearing for the respondent authorities, respondent railways, submits that as per the cadastral survey plan, the railways, the land belongs to the railways.
My railway land plan of 1871.
It is denoted as a railway land. For such reason, the acquisition proceedings was not required for the railways for completion of the project. However, he indicates that since the title has been disputed, which cannot be gone into by the writ court, he submits for relegating the matter to be decided by the competent authority appointed under the Railways Amendment Act 2008. He seeks accommodation to take appropriate instruction. Sorry, since both the sides submits that the matter may be decided by the competent authority, a query has been raised by this court about the period in which the competent authority will decide the issue. Mr. So-and-so, learned advocate for the petitioner, seeks accommodation, respondent railways authority seeks accommodation.
Already appointed the appropriate authority.
Huh?
Railway authority has already appointed appropriate authority has already been appointed.
Seeks accommodation to take appropriate instructions to inform the court regarding the timeline within which the competent authority already appointed under the Railways Amendment Act 2008 would dispose of the applications of the petition. Please this matter on Thursday.
I also prayed for getting the interim order. Your Lordship.
On Thursday we will decide.
And one thing, your Lordship has recorded railway land plan, not the cadastral survey.
Cadastral survey railway land plan.
Our cadastral survey plan shows that the land belongs to us. I have already annexed a Moja map at page 21 of the writ petition, prepared by the ELA collector.
Thursday কি আছে দেখুন এটা টপে উনি
You want any time?
Thursday first half 16th তো না এটাকে উপরে রাখুন ওর কি টপে আছে এটাকে উপরে রাখুন ইনস্ট্রাকশন দিলে তাহলে এটা ডিক্টেশন দিয়ে ডিসপোজ হয়ে যাবে টপ
Books. Well, all other things, my lord, we kept with your Lordship. My lord, only my books.
This plan
keep it, my lord, I will keep it with your Lordship.
এটা রেকর্ড করে দিন railway land plan submitted by learned advocate is taken on record. Hmm.
Item number 2.
This matter I have responded.
Hmm.
Date by Mr. Lolit Mohan Mahato.
Last occasion, it is concluded.
My lord, we have already filed affidavit in opposition.
I am for the record.
In opposition, we have discussed all the points. My lord, page 5. Award has also been declared. And we have already given the name of the awardees.
Page 5 of
Opposition. And we have already annexed the award.
what is the date of the opposition?
My lord, date of the opposition. 19th day of May 2023. Nineteenth day of May 2023.
2015.
23.
Ganapati.
Nineteenth day of May 2023. On behalf of respondent number 1, 2, 3, and 4.
Also WBIDC. I am for the recording. WBIDC. Ganapati is you. Hmm. Yes.
First of all, the land acquisition proceedings initiated in the year two thousand 6-7.
Hmm.
They were declared, my lord. That 8. And name of the award is phase 5, my lord.
Yes.
Same land acquisition proceedings.
Yes.
Merit application filed. Same land acquisition proceedings.
Hmm.
এটা হচ্ছে বিমল কুমার রাজ। 2009 ভলিউম 3 পার্ট 6 পেজ হচ্ছে 454। This is also my lord land acquisition proceedings LAP. Everything discussed. Here after it has been appeal. Appeal also dismissed by the division.
What has been decided in this? What is decided in the writ petition?
My learned friend is not annexed the record of rights. He has only annexed the deed. And on the basis of record of rights, the land acquisition proceedings initiated.
So, in whose name the record of rights stands?
The basis of record of rights, the award has been declared.
What is the case of the petitioner?
Separate case, my lord. I have to say, this is Dr. Bimol's case. There are 6 petitioners. I was not a party to the proceedings.
My lord, only one petitioner, Bimal Rai. Another writ application
And
filed.
others.
Others.
What was this writ petition for?
Petition for setting aside the land acquisition case.
What was the ground on which the writ petition was filed? Setting aside on which ground?
Land acquisition case number given.
There are not two numbers. There is one number. One is LAP and the another is LA case.
AP number and another is
LA case now. Dr. Bimal Kumar Raj, in that case, what was the ground for setting aside the acquisition proceedings?
discuss our opposition. That is also my lord, under challenge. The land acquisition proceedings. Bimal Raj case. And this is the division bench judgment, my lord. না না আমার কাছে একটাই কপি ছিল 540 সব 2000 কত জানি এর পরে হবে 2000 Paragraph 9, it has been discussed that it is revealed to note that out of 405 landowners, land acquired, 400% neither challenged the acquisition nor filed any objection.
Yes. It is which paragraph?
Dismiss, appeal dismiss.
Appeal arising out of which case?
Two cases were had analogously. Bimal Raj and six others. Thereafter, appeal preferred in two sets. This is one set of judgment. But that is also discussed in paragraph 20. Paragraph 20 in the single bench judgment. The next
Paragraph?
argument, paragraph 20, the next argument advanced by the petitioner in absence of any public purpose for the acquisition process, the petitioner would argue that the expression telecom and allied industries must be understood to mean that the acquisition was being made for the benefit of the telecom, a private company. Allied industries, according to the petitioner, would mean associate MS Telecom, a private company. It also argued that the petitioner there can be no public purpose in the acquiring land for benefit of a private company. Large number of independent, paragraph 21, my lord. Both private and public not necessarily related to telecom. The purpose for acquisition of the improved socio-economic condition. Actually, to improve socio-economic condition to the area, generated employment that consequently lead to the overall development of the area, the district, and consequently of the state. The expression public purpose has been explained in detail in the case of Kedarnath Jadhav, state of West Bengal. This is also discussed, my lord, in this judgment. My lord, on twofold round, the award is not received by the writ petitioner, and another section 6 notification is not properly done. And we have already discussed in our opposition, my lord.
What was the finding of the court regarding the public purpose?
That is paragraph 2021. That is also discussed in paragraph 89. The judgment. 90 also. Well, 464 paragraph 22. It has already emerged from the facts related above that the wholly owned the control by the state of West Bengal requiring body for the acquisition. The said WBIDC has put its funds to the extent of 50 crores for the purpose of aforesaid acquisition and declared their proposal dated 9th September 2006. The landlords were paid out of such funds put in by the WBIDC. The instant acquisition process therefore fulfilled requirements of Section 6 since 400 landlords have been paid out of funds put it by WBIDC, the requiring body. Page number 44. In the present case, as already mentioned above, we find that a substantial part of the compensation has indeed been paid by the state government or by the housing board, which clearly satisfies the test of public purpose. In background, we endorse the findings of the division bench that the procedure investigated in part 2 are not part 7 act would be applicable. This that part thereafter, my lord, argued not deposited before the court. That is also discussed.
What has been argued is that the lease deed has been executed in favor of one Ganapati.
My lord, that has
Does
been,
that amounts to a public purpose?
my lord, that is paragraph 20. And 21. Once.
What was the public purpose behind the acquisition? Originally, for which, what public purpose this was acquired?
Originally, this
Vivek Garden Resorts.
It is in our affidavit. In our affidavit, it is estimate of responsibility of the requiring bodies. It has been mentioned in our affidavit that it is about creating industrial parks. Industrial parks, man. It is a paragraph 7 of our affidavit.
But subject to correction, in the original notification which I've annexed at page 37, there's no mention of Vidyasagar Industrial Park or, my lord, Ganpati Flower Mill. Categorically, my lord, at page 37, the notification, it speaks of setting up of telecom and allied industrial units.
Or a name was changed after the process of acquisition. There is nothing.
The part said that, my lord, in the judgment before the learned single bench, my lord, over there, it is mentioned that out of 405 owners, 500 have accepted the compensation and there is no challenge to the acquisition proceedings. But perhaps at that point of time, my lord, it was not brought to the notice of the learned single bench that my writ application was pending before the court and an order of injunction was granted by Honorable Justice Shonjit Banerjee, which was pending on that date, my lord. It was not brought to the notice of the court. Because I filed the writ petition in 2014. And when the writ petition was dismissed in the year 2019, my writ application was pending. But in paragraph 9, it is mentioned that there is no land acquisition proceeding in respect, there is no challenge to decide land acquisition proceedings, my lord, which is perhaps not correct. It was not brought to the notice of the learned single bench that my writ petition was pending. with an interim order, my lord, which was subsisting at that point of time.
You have not received the compensation.
Apart from that, my lord, in Bimal Raj's case, the grounds are different. In my case, the grounds are different, my lord. In Bimal Raj's case, my lord, the issue of two separate land acquisition proceedings, my lord, in respect of the self-same plot of lands, that was not an issue which was agitated before the learned court. And also the judgment, Kedarnath, my lord, I have also placed one judgment of Royal Orchids. The concept of public purpose has been very recent decision, my lord. Yes, my lord, the same issue is over here as well. In the notification, it is mentioned Telcon and Allied in
tomorrow. ওটা পরে রাখো, এটা দেখবো কি আছে। Mr. Mata, you get yourself ready with the questions and the issues that was raised by the petitioner. First is that he says that there are two proceedings, which is not the case here. Because LAP and corresponding number is LA that is recorded in Dr. Bimal Raj's case. So that resolves. The other issue that is he has raised that you have given a notification for public purpose. Now you have made a lease deed with a private company, whether it inures to public purpose or not. And lastly, he has argued that the plot of land belongs to Midnapur Kharagpur Development Authority. He has also referred to section 10, whether the state has withdrawn the notification. You follow section 10 of that, and you will understand that there is a requirement under the Act to have a withdrawal of the notification, whether it has been complied with or not. These are the three precise grounds. So you cover that. First, not answered. First is not required because that Dr. Bimal Raj's case, court has recorded that it is LAP is corresponding to LAK such and such. So there is no question of two proceedings, which he has argued. That is clear from that. But the public purpose, you have to satisfy the court. What is the public purpose in that? Establishing Ganapati. That is also part of that. এটাও দিয়ে দিন tomorrow.
কালকে দুটো সময়
না
ও না কালকে
not true. Day after tomorrow.
বলে না
12 এর সুযোগ হবে কিনা সন্দেহ আছে। এটা ফার্স্ট হবে? আচ্ছা, this will be first time.
may I pick one in?
Yes,
oh,
yes.
oh, yes, sorry.
So that substitution.
Any person that died, substitution has not yet been made. I am for the opposition respondent. Therefore, for confirmation of the other person's death, my lord, I declare 15 days but I. On the other hand, my lord, my unfortunately died. It's a good.
Oh.
Matter will be taken.
So learned senior advocate appearing for respondent. It is 23th unit. If accommodation, এটা same তো, এটা কি monthly list এ নেবো ফেব্রুয়ারি নাকি ফেব্রুয়ারিতে ডেট দিয়ে দেবো? Please this matter after 3 weeks. 3 weeks পরে এটাকে নিয়ে এসো। After 3 weeks. হ্যাঁ
অর্ডার আছে
10th monthly list এ let it appear in the combined monthly list of February. আর
my lord may I beg one indulgence my lord item number 22 other sides are here my lord here direction was made to exchange the affidavit in opposition and reply my lord opposition it was served upon me reply my lord I have affirmed so my lord kindly give a I am handing over this copy 19 copies 19 applicants so 19
But
applicants
share
evident
that
reply
matter. Share
WBSIDC matter,
yes,
my lord,
yes,
that
SIDC West Bengal.
site plan share.
added response.
Added respondents these are all added
No, it is that matter in which there was a work of construction undertaken and there is dispute with regard to share.
no
Not that.
this is my lord only my lord as per the terms and conditions my lord we are entitled to get 25% of
That is what I'm saying.
Yes, my lord. That
we
matter,
are,
my lord.
yes
My
yes
lord,
my lord yes yes
I'm not their
25%
obligation
of
also,
the
my lord,
There is a
building
dispute with
construction
regard
and
to the share.
25% of that yeah education
and also
and
their-
my lord we accordingly my lord filed my affidavit in opposition and my
কতগুলো
lord we are
আছে
serving right now
সবগুলো
22
and my lord,
22 my lord there are 19 applicants in 22
My lord, I am for the added respondent.
added respondents
my lord, one thing, my lord, yesterday, my lord, I received a copy of the affidavit in opposition, my lord. My lord, kindly, my lord, the petition, my lord, allow me to, my lord, file the affidavit in reply, my lord. 19
These are
this is
the
my reply West Bengal-
opposition.
no
reply.
this is the reply
Reply
of
to
the
their-
affidavit in opposition against the writ petition
My lord, I am praying also, my lord, extension of time to file affidavit in reply. My lord, 19, my lord, affidavit
You are
in
for?
opposition. Added respondent.
added respondents that's why my lord this 19
These are my lord by affidavit in opposition.
My lord, I am praying, my lord,
By
extension, my
affidavit in
lord.
Factor
opposition
দিন।
will come, then the reply will come. But what I have done, my lord, for affirmation, my lord, I serve all the advance copy to my lord, I will my online print. Then, my lord, I could
Affidavit in oppositions. Affidavits in opposition. Filed by added respond numbers.
my lord, added respondent, it comes from
Added respond numbers. And
number 1111 2000.
added
And number
respondent
22.
number.
It's my can do can
10. 10.
can 2 of 2023 to can 20 of 2024. Right,
there are so
recently
many added respondents sir yes
can 2 of 2023 and can
Into 27.
can 20 of 2024.
Okay, reply to them. Into 27. No.
Can of 7 to 24, that is the year 2024. Of can 2
Wait, let me find out.
In original writ petition, there is a 12 respondent.
Okay. 13 to 27. Huh? থার্টিন থেকে 27 হলো কতগুলো হলো? How many added respondents are 15?
19
19.
19 numbers.
13 to 27.
19, my
Prior to that, my lord, I filed application, my lord, on 2 occasions.
Oh, আচ্ছা আচ্ছা করে
My
দিস।
lord, my application was allowed by
না এটা নয় এই টাইপিং এটা কটা 29
এটা এক্সচেঞ্জ কি করে হয়ে গেল?
হ্যাঁ এটা নিয়ে কথা হচ্ছে তো উনি কটা করলে
না 27 আচ্ছা
19 numbers of malad added respondents
19
19 numbers of added respondents I have dealt with,
Added
that is WBSIDC.
respondents number 13 to 41
Some are 2023 applications, some are
অনেক বেশি
2020.
13 to 41 কত হলো?
আমার আমার ক্যান গুলোতে না সব লেখা আছে আমার যে রিপ্লাই ক্যান গুলো পাবেন না 19টা সেখানে সব
অ্যাডেড রেসপন্ডেন্টস করে দিন।
and my lord my another submission my lord that yes sorry
Affidavit in reply is taken on record. Copy served. Affidavit in reply to the aforesaid oppositions of added respondent is also taken on record.
yes my lord and my lord position
My lord,
has
as a
already
writ
been
petitioner,
Is this
as a writ petitioner, I am praying, my lord, extension of time to file my affidavit in reply in their affidavit in opposition.
and my lord
There is a
position
19
was taken
advocate-
over my lord kindly record
for the petitioner? 6
the WBSIDCL has taken position my lord
6 বলো okay 6 extension of time to file affidavit in reply to the affidavit in opposition filed by the added respondents.
2 weeks.
Let such affidavit in reply be filed within a period of 3 weeks from date.
and my lord position I have taken over the actual physical position on my lord the date is mentioned here
Keep it with you. At the time of hearing, I will take.
yes
Please this matter in the monthly list of February 2025.
obliged and I'm sorry my lord I'm deeply obliged
Lordship, may I be permitted to mention a matter for inclusion? Lordship, this is WPO number 430 of 2019. It was primarily appeared before Honorable Justice Talukdar. Next, the matter does not appear. Kindly, Lordship, include the matter.
When did it last again? When the matter last? What is the last?
7th November 2019.
2019.
19. For Honorable Justice Subrata Talukdar.
What is the matter? State has filed.
State did not have filed their Vakalatnama yet, Lordship. That's why we have not served yet. Kindly, Lordship, I am praying for inclusion, then I will serve upon the private respondent.
Could you group on it? Notice is the own state.
Lord, may I have my lord's
My lord, may I have your lordship's kind indulgence to mention, my lord, one matter in the original side. My lord, what happened in this matter? The defendant filed an application under Order 7, Rule 11. That was rejected by an honorable single judge of this honorable court. Then the defendant preferred an appeal before the division bench. Division bench passed an order with some modification. We preferred an SLP. The Honorable Supreme Court has been pleased to request the Honorable Single Bench now to decide the matter in the wisdom of the Honorable Single Bench only. The entire wholesome matter, my lord, I am mentioning on notice, my lord, let the matter appear before your lordship, my lord, any day subject to my lord's convenience under the heading to be mentioned. Some checkered history is there under the heading to be mentioned, my lord. May I come back on Thursday? I'm led by Mr. Joydeep Kaur Lanik, Senior Advocate. May I come back on Thursday?
On Thursday, you have given a notice to the other side.
Yes, Lordship.
I have given notice. Ms. Pal is there. We will again inform.
Okay.
Lord, may I have my lord's kind leave, my lord, to mention.
Come back on Thursday. Thursday on under the heading to be mentioned.
Thursday on the papers.
Lord, may I have my lord's kind leave, my lord, to mention a partition suit of 2010. Lord, in this matter, what has happened, Lord? A dispute between interstate parties, Lord. Corporation has been restrained from collecting the taxes. Now, Lord, I want to intervene in this matter and, Lord, get that order vacated. I have applied for certified copies. I have written, Lord, to the parties as well. Parties are not providing the copies, my lord, or copies of the cost title, Lord, nor is the registry providing, because I am not a party to the proceeding. Hence, Lord, I am praying, Lord, for the matter to appear under to be mentioned, Lord, for a direction for me to supply the copies. Because, Lord, in a partition suit, the corporation has been restrained from collecting the taxes, my lord.
You are the?
Lord, I appear for the corporation, my lord, in this matter. I have given notice upon the parties, my lord.
Okay.
But this matter I had mentioned prior to vacation as well, my lord, I am mentioning again. Your lordship may kindly directs, my lord, the matter to appear any day, my lord.
Plaintiff and the defendant, they have been given notice.
Yes, my lord. We have given notice, my lord.
देखिए take दिन
Extremely grateful.
No.
Original side daily list, item number 1.
Hearing at my instance, my lord, and the plaintiff, he had mentioned this matter. Sorry, my lord, as the respondent was one of the added respondents was not accepting service of the affidavit in reply. Now that they've accepted service, the matter is ready for hearing. Your lordship, kindly fix it on any date, my lord.
My lord, this is my affidavit in opposition, my lord.
May I file the reply and the affidavit of service?
The reply also?
Yes, please. And the affidavit of service.
This matter is appearing under the heading to be mentioned. Affidavit in opposition filed by the
Dilon Kumar Saha. He's not a party, my lord. I had sought leave to serve upon him. He's not a party to the...
That is, this tenancy has changed. Yes, partnership name has changed.
Yes. That matter, my lord. Your lordship, recollect.
You are appearing.
Yes, madam.
Filed by affidavit in opposition filed by
Dhilon
Dhilon Kumar Saha, proprietor of, he's a proprietor.
No, it's not a
partner of the defendant company now.
No, Malad, that is what is disputed. Yes, Dhilan
Saha,
Kumar Saha, Your Lordship.
Dhilon Kumar Saha is taken on record. Affidavit in reply, next line, affidavit in, আচ্ছা, ওপরে দিয়ে দিন, copy sir. Affidavit in reply filed by the applicant, plaintiff is also taken on record, copy served. Para, both the learned advocate submits for fixing a date for hearing of the application. Please, this matter on 17th.
Lordship is February. Some precedents, Malad. It's a very short point, and this is a very old suit, Malad. It's a suit. Oh, Jalpaiguri.
I'll be Jalpaiguri on 31st.
Not before 31st, it does not. Lordship's roster, where board does not permit Malad before 31st.
After 17, 19, from 20th to 31st, I'll be Jalpai.
20th.
31st.
Oh, monthly list. Wait. Lordship is.
Item number 2.
Wait, please, my lord. Do I appear for the plaintiff? I have an application in this matter, my lord, which was to be heard today, my lord. GA 25.
My lord, I appear for the
27.
defendant number 2, if I may. My lord, I'm praying
GA
for not to.
27. 15 was also supposed to be.
15 was supposed to be there, my lord. We have taken instructions, my lord, that it is not traceable.
What is 15 of 2004?
Lord, 15, we have absolutely no instructions, my lord. Who has filed it? Or
My lord, I'm for the defendant number 2. I'm praying for not today, my lord. I'm being led by Mr. Shubhashish Sengupta is not here.
My lord, the impediment, my lord, for me to place 27 is because my witness action is pending, my lord. On the last day, your lordship remembers, there was vehement opposition, my lord, on the side of defendant number 2, not to get this application allowed. The reason being, my lord, very short point, 2003 injunction granted, 2004 contempt disposed of because there was a threat to the property. 15, 2008 receiver appointed, 2015 receiver changed. Now we are 10 years down the line. My prayer is only, my lord, not to take and inspect the area, is just to go and visit and to see whether that order of injunction is intact or not.
Where is the property?
Property is within, my lord, One India Exchange, my lord, near the Calcutta Stock Exchange.
Tomorrow.
Very well, my lord. Kindly
Not
keep,
today.
Kindly keeps it, my lord, tomorrow under to be mentioned, my lord.
It will appear under to be mentioned only tomorrow. Not today.
Not today. Very well.
Grateful, man.
এটা কালকে একটু এ করবেন, এটা 2004 হবে, GA 15.
Lord, will it be my lord's pleasure to pass a one-liner order? Very well, very. यही बोलছেন order. Oh.
Item number 3.
Yes, yes. Yes, my lord. He's coming, my lord. Mr. Banerjee.
My application.
Similar that your lordship had heard on the last occasion, where party receivers, orders of court already there for sale of property, were taken out another application. But last time we had identified a borrower, a buyer. That buyer had put in the money, thereafter not paid, so we cancelled and came to your lordship to give leave to sell it to somebody else. Here, we want to make an advertisement for sale of the property. But I think last time, service was an issue. This time I'm told we've served on everybody. For state. No, state.
We have no
Lord, we've served the state. Because state had come on the last occasion in that matter and sought for time. Application about. Eta. Kunta. Ye tujhe se. pages 32 to 41, Your Lordship will find previous orders primarily at page 40. There's an order of 22nd of July 2015. এটার পরে আমি কোথায় এটার পরে কাউকে আর পাই না, না এই প্রদীপ ভদ্র বিক্রি করতে চাই।
যেটা ওই ইয়ে মুভ করছিল না আমাদের এই মুখার্জি স্যার, মুখার্জি, যেটা আমি রিলিজ করে দিয়েছিলাম, আবার বললেন অ্যাসাইনমেন্ট হয়েছে। ওর কত নম্বর আইটেম ছিল মনে পড়ছে? নাম্বারটা বলুন। কেদারনাথ ছিল, দেখুন তো এই জি এর এই অর্ডার চলে চ্যালেঞ্জ করেছে, দেখতে পাবো এটা?
এটা আমার মাস থেকে আসছে, এটাও মাস আছে।
কেদারনাথ ছিল, ওদের একটা ফ্যাক্ট ছিল যে ল্যান্ডটা ওয়েস্টেড হয়ে গেছে, তা সত্ত্বেও কোর্ট থেকে অর্ডার বার করছে সেলের, ও যেটা মুভ করছে। Yeah, you have paid for publication of this.
So, if your Lordship looks at paragraph 4,
No, at the first instance, Smart
yes,
Microtech Private Limited was the intending purchaser.
Yes.
Confirmation of sale was in favor of that purchaser.
Yes.
After that, he has not made payment.
After that, he's not made any payment.
So that confirmation fails. Now you have the self-same property you have sought for sale.
Sale to somebody else.
Valuation of the property has already been made by the valuer.
Well, in this matter, there is no mass. Mass was in the last matter that was moving before your Lordship. This, your Lordship, is looking at GA 206.
At page 36. 1788 of 15. This is that order.
This is in the other matter, my Lord.
Oh. Which is this order? Page 40.
These orders have been shown, have been annexed to just show that from time to time courts have permitted us to sell properties in favor of identified purchaser.
Oh.
It's with that intention that we've annexed these.
Okay.
If your Lordship looks at paragraph 4 now, why this application necessary? Page 20, paragraph 4. These persons have now approached us at 3 lakhs per kattha on as is where is basis. But your Lordship is right. There is no valuation really that at least we've mentioned of. We just have mentioned that the offer has been made of 3 lakhs per kattha. But if your Lordship is otherwise permitting us to sell the property to these persons, then kindly provide in the order that we shall not sell it at lower than a circle rate at least.
While
No, circle rate
later valuation report be submitted by the registered valuer of the High Court.
With regard to?
Yes, thereafter we can take up the matter for publication, because publication should have
if the valuation is very high, no one has come forward to really buy it. So these persons are buying it at 3 lakhs per kattha. and it's a fully encroached property that also be mentioned in the application. And the requirement to sell it is because now we are not being able to control the encroachments on the property. That your lordship will find a specific pleading also, that the requirement to sell is because of the encroachment.
You are for the Kundu Chaudharis.
Yes, I am for the.
All have given their consent to sell at 3 lakhs.
Yes, they are all here, I think.
Because regarding payment of stamp duty, that will be decided by the register on the basis of query to be supplied by the government. That the buyer will be liable to pay. But we will be happy if we get this amount, madam. Because if I purchase a flat at rupees 10 to a 1 crore, government valuation 2 crore, then I have to pay the stamp duty for 2 crore. And I may purchase at 1 crore. Stamp duty would have to drop. At the time of registration, otherwise registration will not be done.
And at page 15, your lordship will see that this application is being taken out by the defendant number 2AII, which is a party receiver. And all the other parties appear to be here. State we've served, they've not come. So and 2020, after 2020, you've not received any further offer also. Not like anybody else is interested in buying the land. We can't contain the encroachments any further. So we want to sell these plots, which are there in favor of. And all these orders that your lordships noticed are just to highlight the fact that this has been the practice in this suit, where courts have repeatedly passed orders allowing us to sell it to persons that we've identified.
Is there any minutes of a meeting
Not that
of the owners to arrive at a particular offer price?
But
So this is not been disputed by the owners. The owners, they offer for selling the property at 3 lakh per cut.
The lordship has seen this has been pending for 4 years. No one's taken out an affidavit. I'm told all of them are represented. They are also consenting for it to be sold at this price.
Publication is at which prayer number?
I'm sorry, my lord.
Publication, you have sought for publication?
No, my lord, you've not sought for publication. It's more like a private sale that's happening through the AGs of the court.
What is the requirement for the order of the court for the private owners to sell their property?
So the suit is pending and property is custodial edges held by party receivers. So
Okay.
when receivers want to sell, they'll have to
Seek for.
take the.
Okay. ഇത് എന്ത് ചെയ്തിരിക്കുന്നത്? Affidavit of service টা কোথায় আছে? অঞ্জন বাবু, affidavit of service.
On the last occasion, the state had not appeared. Your lordship desire was to be served and came back. Now we've served, my lord. I've seen it. Page 25, prayer B, if your lordship could just consider. All the details are there. More importantly, as is where is whatever there is basis. We'll be selling it with encroachment. Details of particulars page, right? পজিশন দেওয়া এসব করতেই হয়।
This is an application filed by the joint receivers. They are different numbers.
2AII. Well, I find only one receiver has come here.
Application filed by
One
one of the joint receivers, namely defend number 2AII II in the suit, seeking leave to sell property of the joint estate of Kundu Chaudharies on as is where is basis.
Lordship, will forgive my interjection. I'm sorry. The other receiver is also being represented by my learned friend.
But he has not filed the application.
No, but he's giving a consent to the sale.
Okay. At the time of passing of the order,
Yes.
more fully specified in para 4 of the application. Mr. So and so learned advocate appearing for the applicant submits that the owners have consented to sell the property in whose favor?
That in favor of the parties mentioned in paragraph 4.
In favor of
Pradeep Kumar Bhadro, Shankarlal Das, and III, slightly unusual name, Baby Das.
para 4.
Para 4, sentence wise is there. Pradeep Kumar Bhadro, line about 5 from top of paragraph 4.
In favor of
Page 20, paragraph 4. Or your lordship will find the particulars in the prayers also.
Okay. Pradeep Kumar, in favor of Pradeep Kumar Bhadro.
But may I? My juniors have.
Comma, Shankar Lal Das and Baby Das. At the rate of rupees 3 lakhs per kata on as is where is basis. Mr. So and so learned advocate representing the other joint receiver consent to the aforesaid sale. Mr. So and so learned advocate for the majority shareholders also does not raise any objection. Accordingly, let there be order in terms of prayer A of the notice of motion. Leave is granted for sale of the property more fully described in paragraph 4 of the application to the aforementioned intending purchasers on as is where is basis. The sale full stop. The sale should be completed within a period of 2 months. GA 206 of 2020 stands disposed of. ওপরে না affidavit of service টা লিখে দেন affidavit of service আমার এটা আপনার এই প্লেনটা কারেকশন হয়ে গেছে ওই যে যেটা ডিকটেশন দিয়েছিলাম সুটে ওটা কারেকশন হয়ে গেছে আপনি থাকবেন ওটা আপনার কাছে যাবে ওটা আপলোড করে দেবেন
ওটা লাগবে না আগেরটা দিয়ে দিবে সেটাই হবে আর ওটা দরকার নেই
Item number 4.
Your Lordship, I'm appearing on behalf of the applicant hearing. The applicant, this is a matter wherein a grant of probate, application for grant of probate turned into a testamentary suit. It was in the stage of witness action. In the meantime, Your Lordship, the executor and executrix, that is the plaintiffs, have Your Lordship passed away. The sole legatee of, according to the will, is filing this application to turn this into a letter of administration and continue the proceeding. This is the sole prayer of the application.
Now, we have been instructed to appear for the sole defendant. This suit is probably appearing subject to correction after a period of 12 years.
Yes, true.
Now, on Friday, 10th at 3 p.m., they have served this copy to my client. Now, thereafter, we have initiated the process to get a contact an advocate and to get a no objection. We hope we will get it by this week, my lord. So, and we will file our wakalatnama and then only I can make my submission because my client has objections regarding this application.
This is an application for amendment. Mr. Swenso, learned advocate appearing for the petitioner submits that during the pendency of the suit, both the executors,
Executor and executrix both have
both
passed
the
away.
executor and executrix have expired. The applicant, being the sole legatee, has applied for amendment of the application for grant of probate to one for grant of letters of administration. Mr. Meghnad Dotto, learned advocate for defendant, submits that his client has received the copy of the application on
10th at 3 p.m.
10th January 2025 and he seeks to file affidavit in opposition after filing of the wakalatnama on behalf of his client. Let such affidavit how within 2 weeks?
3 weeks,
within a period of 3 weeks, reply the to any by 1 week. This matter after 4 weeks.
Gratefully, Lordship.
Great.
Item number 5.
I appear for the petition.
Lord, I appear, my lord, for the respondent number 6, 8, and 10, my lord. My lord, kindly allow me to join virtually today, my lord.
I have the respondent number.
kindly have a look at your lordship's order passed on the last occasion.
Yes. Where is the opposition?
My lord, my advocate on record is there, my lord, with a copy of the opposition. My instruction is that it was served upon the petitioner long back. It could not be filed in court, my lord.
But if it is the old affidavit which was served on us, may the reply be taken on record. The pleadings are complete then. So kindly, my lord, fix a date, my lord, for hearing of this resolution.
Is there any other parties who will be filing any pleadings?
Everybody has filed. That is already recorded, I think,
Okay.
by your lordship.
Affidavit in opposition filed by respondent number 6, 8, and 10 is taken on record. Copy served. Para affidavit in reply filed by the petitioners is also taken on record. Who is representing respondent number 1, 2, 3, 4, 5, and 7?
They have filed. They have filed. I am for 5.
And your reply is also been filed. Learned advocates for respective parties seeks for fixing the matter for final hearing. Bolun.
But would my learned friend serve me copies of his opposition?
Amra opposition.
One to respond to the state, but we don't have. Oh, not the state respondents, not affidavit. We don't have.
6, 8, and 10. This opposition.
He is asking for a copy of the affidavit used by the state. As a correspondent, he is asking for a copy.
Who is for the state?
Earlier, the Advocate General was appearing, but AG has appeared not when it was heard on 1st September 2017.
Yes.
And my lord, if I may, the petitioner's affidavit in reply, my instruction is that that copy has not been served upon us. Let the petitioners.
We'll send a copy.
I'm grateful now.
State to কোনো কেউ নেই. None appears on behalf of the state.
Yes, sir.
Learned advocate for the petitioner is directed to intimate the next date of hearing to the learned advocate for the state.
Yes.
Mr. Bachawat, since state is not appearing, I'm not passing any direction. Let the matter appear on the date fixed. In the meantime, they will serve a notice intimating the next date of hearing. কবে আসছে বলুন?
But respondent number 3 is appearing, but can we also, that's Calcutta Municipal Corporation. Can we get a copy of their affidavit?
Okay. Respond number 3.
Yes.
Achha. Learned advocate for respond number 3, Calcutta Municipal Corporation is directed to hand over a copy of their opposition to learned advocate on record for
number 5.
Respond number 5.
Well, may we also get a copy, my lord, of the KMC affidavit, the respondent number, my lord, 6, 8, and 10.
Our 10th February.
10th February.
I was also requesting for a copy of the KMC affidavit.
Person approach your friend to have a copy.
Yes, my lord, I will do that. Grateful, my lord, deeply obliged.
But instead of 10th, can it be the week after that? I'm not there for 3 days of that week.
17th.
Deeply.
Mr. Kaur, 17th.
Grateful, my lord, deeply obliged.
For hearing item number 6.
Would I appear for the propounder in this matter, Lord? Executor as well as the beneficiary. So the will of the Lord testator or the deceased, Lord, is dated Lord May 17, 2006. It's a registered will. The testator, Lord, had died on 21st of November 2008. So thereafter, Lord, the application Lord, for probate has been filed in the year 2009.
Arjun Kumar Roy is the testator.
Testator. Arjun Kumar Rai is the testator.
21st
Will
of
dated Lord 17th of May 2006. Registered will. Testator died on 21st of November 2008. Now, Lord, this probate case, Lord, initially was contested. Lord, his wife, Arjun Kumar Rai's wife, rather widow, Lord, had lodged a caveat. Thereafter, Lord, she had used a affidavit in support of the caveat. During the proceeding, Lord, he expired, and your Lordship she expired, Lord, and your Lordship was pleased to expunge her name from the array of parties, and thereafter, Lord, because this was once being Lord converted in a contentious cause, Lord, that's why now I have to Lord make all the proof Lord in the solemn form. Lord, one of the point taken was with respect to jurisdiction. Lord, because those points were taken, Lord, I must try and dispel all those doubts from your Lordship's Lord conscience. Lord, kindly comes to the affidavit of assets.
An affidavit of asset.
But because this was filed in the original site, that's why they took the point of Lord jurisdiction, because the civil court, city civil court will have exclusive jurisdiction if the property is situated within original site. Now, Lord, kindly comes to the second page of the affidavit of asset. Item number B, Roman 4.
Yes.
Situated outside jurisdiction. So, Lord, the first answer to the jurisdiction point goes. Because it is situated out, some of the property is situated outside the jurisdiction, section 300 will come into play instead of Lord, the restriction of City Civil Courts Act. So that's why, Lord, we will have that jurisdiction. Now, Lord, with respect to the proof of the will, Lord, kindly comes to
the other three properties, comes within the jurisdiction of this court.
Yes. India Exchange Place, Foriapukur branch, to our Foriapukur branch.
These are within the original site.
Okay. Only because one of the properties outside jurisdiction, that's why City Civil Court cannot grant plot. That's why this court exercising section 300 can. Now, my lord, kindly comes to the affidavit of attesting witness. Dilip Kumar Chandra. And my lord also turns over to my lord page 12 of my petition.
Page?
Lord, first page 12 of my petition. That's the last page of the will. Your lordship.
No, attesting witness, what are you referring to?
First name, Dilip Kumar Chandra. Kindly comes now, my lord, to the affidavit of the attesting witness.
Yes.
Dilip Kumar Chandra has affirmed. Lord, paragraph number 3. After the testator read over the said will, he put his signature and executed the said will in our presence at the request of the testator, myself, Mr. Such and Such, in presence of the testator and in presence of each other, signed the said will as witness. Similar requirement of section 63C complied with. This my lord, witness was subjected to my lord, cross-examination. So that was held in commission. Lord, your lordship was pleased to direct my lord to send the officer to go and get the signature from the deposition commission. I'll try and show two things. One is the execution of the will, and the other one is that this will was not unnatural. That can also be deciphered from this evidence. Lord, question number 3 first. He knew Arjun Kumar Rai from 1939. Kindly turns over to question number 9, 10, and 11. Proximity with Arjun Rai during the more or less, he was my patient. Can you say such and such? And also very good physique, better than us. He was healthy and hearty. What about mental condition? Normal. Question 16. Who are the persons who have signed this will? Lord, again, the same question was put. Paragraph 3, I have shown to your lordship, same question was put. 16, your lordship would find he stands to his answer. Where did all these persons put their signature before in my presence? I am asking you such and such. In the office of Pulak Chandra Das. What did he tell you? Lord, question number 21. What did he tell you? He asked me to come to sign this will. So, Lord, the animo attestendi was also there. That he knew that he was going to sign the will as a testing witness. So, that was also there. Kindly comes, Lord, to question number 22. Do you know anything about the marriage of such and such? He was married to, so Lord, he knew. Question 28. Can you identify your signature, encircle it? With the signature, so Lord, it was encircled, done. Kindly turns over, Lord, to question 29 to 34. What happened after? I'm sorry.
Yes.
What happened after the will was signed in the office of Pulak Chandra such and such? We went there and signed in presence of Arjun Kumar Roy. Then we went to registration office and it was registered there. Can you please specify the sequence? Arjun signed first and then Mr. Dhar signed and thereafter I signed. No, two attesting witnesses. Did you all sign in presence of each other? Yes. Will you be please indicate such and such? Lord, this is will of Arjun Kumar Rai. Witness again encircles the signature of Arjun Kumar Rai. So, Lord, that was also done and it was exhibited. And Lord, subsequent exhibition of the will was Lord tendered here. Your Lordship would remember, Lord, it was marked as an exhibit in this court. Kindly, Lord, turns over to question number 65 to 70. Please name the family member who told you, rather, how do you know that he was suffering from cancer? Question number 64. From his family, and he also told me. Please name the family member who told you, Obijit and his father. Lord, Obijit is the propounder of your lordship. What was the relationship between Obijit and Arjun? He was his nephew. He was his nephew. Was he living with Arjun? No, he was living in his house. Why do you say that Arjun had with Obijit in his family? Arjun had no other members to look after him. So Obijit came in his house. Thereby, according to you, Obijit became the family member of Arjun. He used to look after him, living at his own house. Yes. No, these are all in cross-examination. Thereafter, your lordship would find, Lord, that he was medically fit. Lord, those questions were asked in 75, 76, 77. Lord, everywhere the same thing was answered. Kindly comes to 90. Lord, I am just hurriedly taking your lordship, Lord, just to indicate. 91 to 94. Today you have said that you have been to the office of Registrar Assurance for registration of the will. Is that it? I went to the office of the registrar with the others. For what purpose you had been there? I had signed it in Pulak Das's office and then I went to the registry office with Arjun. What was the location of registry office? Red Cross Society. Please let us know who presented the document. Arjun presented the document. Lord, these were all questioned, not and answered also. So, my lord, by this, your lordship would find, my lord, the compliance of section 63C was complied with, along with, my lord, section 68 of the Indian Evidence Act was that also complied with. Now, my lord, with respect to some of the that he was active after making of this will, my lord, those documents, my lord, were also exhibited. Lord kindly takes the Lord deposition of Lord Abhijit Dhar. Lord, question number 13. Lord, this is with respect to the relationship of propounder with Lord the testator, just to establish Lord that the will was not unnatural. Question number 13. How was your relationship with the testator? Actually, I am the nephew such and say. He treated me as his own son because his own son was dead at that time and his wife took her son to her matrimonial house and did not come back. Now, question number 10 to Lord 12. Your lordship would find Lord, the statement with respect to his health and mental Lord health, physical health and mental health. 10 to 12.
Yes.
Lord, Exhibit C was Lord is the passbook. Lord, kindly takes judge's brief of documents once. That would Lord would suffice. From the original passbook, Lord, your lordship would find page number 3. Lord, he died in November 2008. He died in November 2008. From the entry, your lordship would find, Lord, the last entry is on 20th of October 2008. Monies are occasionally withdrawn, a regular basis. So, Lord, he was active till before his death. Thereafter, Lord, your lordship would kindly come to Lord, page number 35. এটা কত? এই deposition of Arjun Kumar Rai. এটা কত exhibit? Please, 35. 41 and okay. Lord, I shall not give the exhibit number, Lord. This was also exhibited. This is the deposition of Lord Arjun Rai before Lord the Additional Chief Metropolitan Magistrate, Lord, on 2007. March 2007. So after making of the will, he was in a position to depose before the court. Your lordship would find, Lord, from page 41.
So where is the date of deposition?
Yes, Lord. Lord, the date of deposition, your lordship would find, kindly come at page 38. Kindly comes at page 38, Lord. Lordship, kindly got it, Lord. Middle further cross-examination resumed on 19th of March 2007.
So this was previous to that. In 2007, he was in a position to depose before the court. Lord, kindly come. This is Exhibit I. This is Exhibit I. Written statement. Lord, kindly comes to page 41. A partition suit was filed in 2005 with respect to this particular property.
Page?
Lord, page 41 it starts. Kindly comes to page 42. This is Exhibit K. Now, my lord, a partition suit was continuing between the other sisters and brothers, my lord. The name of the plaintiffs, your lordship would find. Sisters, some brothers are there. Defendant number 1 is Arjun Kumar Rai at page 44. And my lord, this written statement was, my lord, affirmed in 2005 itself. So this is only to show, one is that he was actively contesting the suit. The other aspect is because he had a strenuous relationship with his wife and he had no son. So there was all chances for the other heirs, for the brothers and sisters to come into his share. That's the reason why it was important to make this will in favor of a particular person whom he wanted that property to go. So that's why it is not something which is unnatural. And with that also with the given relationship which I had indicated. Kindly my lord comes to page 98. 98 is not required. Lord, kindly comes to page 85. এই applicationটা কত হয়েছে এটা বলুন। This is Exhibit M. Page 85, this is Exhibit M. Lord, the signature of Arjun Rai is at page 93, although that's not important. What is important is, Lord, it was filed on 10th of July 2006. Immediately after the will was made. So, my lord, he came up before this honorable court. This is an objection, opposition, affidavit in opposition, Lord, in connection with an application filed in the partition suit.
Yes.
So, my lord, with respect to the reason why I'm trying to demonstrate that he had a reason to dispose of his property. It is not that one fine morning he gave it to someone else at third party. He had a reason. He had a problem going on at his home with respect to his, so protection of this property was primordial importance. But that is exactly what the Lord Testator has tried to do. Lord, the will, although Lord not required, Lord, I will not place the will, there is not requirement. Lord, with respect to the signature and execution, I have shown your Lordship. The attesting witness was thoroughly cross-examined, although today it is irrelevant. But then also, because it was done, I had shown to your Lordship, he stood to what he said. That Lord, section 63 compliance is done, and there was also animo attestandy. So he knew that what he is going to do. So that is there, that covers. The signature of the testator was identified. The persons who were there at the time of execution of the will identified. That testator was physically and mentally healthy. Those I've shown from the deposition and from the documents also.
that he was active and that Lord, he had reasons Lord, to make this will, and it is not unnatural. That is also from the documents I have shown to your Lordship. Now, Lord, only two judgments. Lord, Lord, 2018 3 CLJ, Lord, 505. Paragraph number 11.
Yes.
By her affidavit, the defendant has not come forward to challenge the execution of the will, nor has she produced any witness to dispute the authenticity of the execution. It is profitable to discuss about the essential tests for valid execution of a will. According to the provisions of Section 63 of Indian Succession Act, the will must be signed by the testator, or testator shall affix his mark to the will, or it shall be signed by some other person in his presence and by his discretion. The signature or mark of the testator or signature of the person signing or for him shall be so placed. Not this Section 63 produced. The will must be attested by at least two witnesses, each of whom has seen the testator signing or affixing. So this was complied with. From the discussion made herein above, it will be clear that requirement under Section 63 of Indian Succession has been duly fulfilled. According to the provisions of Section 68 of Indian Evidence Act, only one attesting witness is alive, and here is also the same thing. Now two attesting witnesses have died. And subject to the process of the court and capable of giving evidence, has to be called to prove the execution of the document. It would be incumbent on the propounder or the person claiming under the will to prove that the said document was executed as required under Section 63C, and then only the document can be given effect to as will. One of the attesting witnesses, a witness, has deposed in the box and has proved the execution of the will. Therefore, there is no reason to disbelieve the execution of the will. So this is one. The other one is Lord 50. Lord, although Lord there is no requirement for Lord a will to be registered, Lord, but our High Court Lord says Lord some gravity should be given if the will Lord is registered. Lord, this is reported in 2023 SPC Online Calcutta 616. This is a division bench judgment. Page paragraph Lord 55.
Yes.
My lord, kindly got it. A registered document raises a presumption under Section 114 of the Evidence Act to the effect that the events contained in the endorsement of registration duly performed and correctly recorded and being duly certified by registrar of the document, but it does not contemplate the factum of attestation within the meaning of Section 63. Similar with respect to 63C and 68, my compliance is done. Lord, the judgment has cited. So Lord, my part with respect to that is complete. In addition to that, Lord, this is a registered deed, and that's the reason why Lord, the presumption with respect to the sequence of events that took place while registering the will be presumed, unless Lord otherwise.
Attestation of the will cannot.
Paragraph number 57 is also important.
Yes.
And 58. But Lord, from this judgment, Lord, what I wanted to show is with respect to Lord the gravity of registered will. Nothing more. So the objection with respect to jurisdiction, Lord, I have submitted. With respect to execution, Lord, I have made my submission. With respect to the will not being natural, unnatural, not being unnatural, I have made my submission. And also, my lord, the testator was otherwise physically and mentally healthy. He knew what he was doing. These, my lord, are my respectful submissions.
Achha. Caveat has been discharged.
Yes, yes. Her name has been expired.
By which order?
My lord has not passed that order, my lord. Order tabon. I shall. Lord, this is the order, my lord.
22nd.
And Lord, thereafter none has come forward, Lord, despite knowledge. From the partition suit, Lord, I have indicated.
Might be the caveat discharge is a vacation.
Kuri.
This is an application for grant of probate of last will and testament dated 17th May 2006 of the deceased Arjun Kumar Roy. The wife of the deceased testator filed caveat and affidavit in support of caveat. And the probate application being contentious was converted to a testamentary suit being 16 of 2009. It Indian Succession Act link.
My lord, can you take small?
It is here. Evidence Act. Need. By order dated 3rd July 2024, the name of the caveator was expunged for the reason of her death. Caveator naam diye din, Phul Rani Roy. For the reason of her death on 26 March 2024. The plaintiff's contents as follows. Paragraph. The Arjun Kumar Roy, the testator, died on 21st day of November 2008 leaving behind his last will and testament executed on 17th May 2006, registered before the Registrar of Assurances, Kolkata. At the time of his death, the testator was a Hindu governed by Dayabhaga School of Hindu Law. The said will was executed in presence of Dr. Dilip Kumar Chandru, and what is the name of the other attesting witness?
Bhupati Dhar.
And Sri Bhupati Dhar. The petitioner was, plaintiff petitioner was appointed as the sole executor in the said will. The deceased had only one legal heirs, namely his wife Srimati Phul Rani Roy, who did not consent to the grant of probate. In order to prove the will, the in order to succeed in the prayer for grant of probate, two aspects are to be established. Number one, whether the testator was in fit state of mind and physically fit and mentally prone. Whether the testator was physically fit and mentally alert to execute the will. Number 2, whether the will executed is beyond any suspicious circumstances. এই জায়গাটা একটু আন্ডারলাইন করে রাখ, এটা একটা জাজমেন্ট। In order to prove the execution of the will, আচ্ছা না, তার আগে মনে সাবমিশনটা নিয়ে নিই। Mr. Rahul Kormokar, learned advocate appearing for the plaintiff petitioner, submits that the will is a registered will and the same has been proved by examination of the one of the attesting witness, Dr. Dilip Kumar Chandru, as per requirement of section 68 and 68 of the Indian Evidence Act and section 63C of the Indian Succession Act. The evidence of the witness would show that the testator was physically fit and mentally alert on the date of execution of the will. There are no such suspicious circumstances to disbelieve the execution of the will. The executor is the nephew of the testator. And in order to protect the property, the will has been executed, appointing the petitioner plaintiff as the executor. He also, referring to Exhibit C, Passbook of United Bank of India, Exhibit I, the deposition of the testator, Exhibit K, a written statement, and Exhibit N, Nagpur, N. Affidavit in opposition filed in a GA application submits that on the date of execution of the will on 21st May 2005. ঠিক বললাম? No, 17th May 2006, sorry. 17th May 2006, the testator was very much active and alert. relying on the decision of this court passed in, এটা দেখে নেবেন, সমীর কুমার বিশ্বাস, না সুপ্রিয়া বিশ্বাস, সুপ্রিয়া বিশ্বাস versus মুনমুন নিয়োগী, 2017 SCC online Calcutta 17386. He submits that since the requirement of Section 63 of the Indian Succession Act has been duly fulfilled and the provisions of Section 68 of Indian Evidence Act has also been satisfied by proving the will by one attesting witness, the petitioner plaintiff is entitled to grant of probate in his favor. He also submits that since the will is a registered one, it carries with it a presumptive value and a weightage. To buttress his contention, he relies on the decision of this court passed Tapoti Patra and others versus Swarup Das and another, reported in 2023 SCC online Calcutta 616. Having heard the learned advocate appearing for petitioner plaintiff, it is to be examined whether the execution of the will, the requirement pertaining to execution of the will under law, has been fulfilled or not. In support, the petitioner plaintiff has examined the attesting witness, Dr. Dilip Kumar Chandru. In his evidence, the witness has categorically stated that at the time of, that the testator had a very good physique and his mental condition was normal. He further deposed that the testator was fit to understand everything, always. Furthermore, deposed that he came to the office of the learned advocate Mr. Pulok Chandra Das to sign the will. Which is that question regarding signing and the chronology of signing you have just indicated?
Lord,
He deposed that.
kindly comes to paragraph number, Lord, question number 16. 16, 17, 18, 21. And thereafter, question number 30.
This witness further deposed that the testator Arjun Kumar Roy, the other attesting witness, and the learned advocate Pulok Chandra Das signed in his presence. And he has also signed the original document in the office of Pulok Chandra Das.
Question number 30, 30.
30. After the testator has put his signature and the executor also put his signature.
My lord?
Executor also put his
No,
signature.
no.
Who is Mr.
Executor's
Dhar?
signature is not there.
Mr. Dhar, this is?
Dhar is Bhupati Dhar.
Bhupati Dhar.
Bhupati Dhar, the other attesting.
And the other attesting witness. And thereafter he signed on the said document. He also deposed that Sri Arjun Roy, testator, presented the document in the registration office along with his pleader. This witness identified the signature of the testator on the will dated 17th May 2006, as well as his signatures and signatures of other attesting witnesses. Okay. Rigid, Arjuna. Other attesting witnesses. Hmm. Evidence. Section 68 of the Evidence Act provides as hereunder. 63C of Succession Act. From the aforesaid evidence, it is found that the plaintiff petitioner has fulfilled the provisions of Section 63C of the Indian Succession Act as well as the requirement under Section 68 of the Indian Evidence Act. Further, it is relevant to note that there is no suspicious circumstances coming up in the evidence to disbelieve the contention of the petitioner plaintiff. Accordingly, the execution of the will stands proved This court finds substance in submission of Mr. Kormokar, referring to Supriya Vishwas. Although reliance has been placed on the decision of Tapoti Patro, on the proposition that a registered document carries weightage, I beg that this court differs on such proposition in view of the fact that the decision observes that though a registered document raises a presumption under section 114 within bracket illustration E of the Evidence Act, but due attestation of the will cannot be presumed merely because the will was registered. In view of the above discussion, let there be order in terms of prayer. C. Of the petition caveat accordingly stands discharged. This suit is decreed in terms of the prayer A of the petition. Department is directed to draw up and complete the decree as expeditiously as possible. Urgent photostat certified copy.
Great. Perhaps at the last blood, your lordship has recorded prayer A of the petition, but perhaps it will be
Oh, prayer C হবে, sorry, thank you. Prayer C, ওটাতে continue করে দিন. Would be decreed in terms of prayer C.
Great.
Item number 7.
I prefer the respondent.
Your Lordship, we hadn't finished. We were still continuing on the last occasion.
Where is Mr. Datto?
I just briefly encapsulate what we had submitted on the last occasion, Your Lordship. The present application is for restoration. And that
Wait.
I appear for the intervener.
Hmm.
The party, but I've purchased the property. Now,
written disclosure, no one, it's just bare denials. Doesn't say anything that they've purchased the property.
exhibited in the proceedings of the suit, in various orders, lordship.
Lord, apropos what my learned friend had said, Willard, it's right that he has purchased the property. And he has purchased the property according to him, Willard. It was brought that he purchased the property at a time when he says that the suit was dismissed. And I say that the suit was not dismissed. The suit was subsequently restored, and that order I had shown to your lordship. Number one. The fact that he has not been made a party because the suit is dismissed, but we have taken out leave, and on the pursuant to the leave, we have served him, so that the order does not affect his rights if at all. Now, my lord, on the last occasion, I was actually trying to impress upon the court that the right to sue survives.
both on the count of the plaintiffs and both on the count of the defendants. I had showed to your lordship, my lord, that admittedly the property which my learned friend's client said to have purchased is a Shebayat property. Property belongs to the deity. If not to the deity, at least the income of the property is charged to the deity. So therefore, in either way, this property could not have been dealt with without the leave of court. That was my first submission. My second submission was that the orders, that the records show that as on the date of filing of the suit, there was a receiver which was appointed over the property for the purpose of collecting the rent. That order
এগুলো অনেকক্ষণ চলবে মনে মিস্টার দত্তকে জিজ্ঞেস কর It will continue, no, Mr. Dottu? Oh. Yes, other matters.
All other matters are released for today.
Millard, page 57.
Yes.
Millard, your lordship will find that this is an order passed by my lord Mr. Justice Soposhachi Mukherjee Millard, as his lordship then was. The Millard, the drawn up copy of the order is at from page 48 and the typed copy is at page 57. So Millard, if your lordship wants, I can just showing that it's there. May I just please it, Millard? Upon reading the part of the plaintiff's notice dated 13th day of July last from Mr. B.P. Mullik, the advocate to the defendant Balaram Mullik, and Mr. B.N. Chatterjee, advocate, and the defendant Lalmohan Mullik and T.S. Banerjee, his advocate, and affidavit of such and such. Then the parties are given. Kindly come to page 58. It is ordered that at a remuneration of 15 gold mohurs per month, Mr. B.N. Bhattacharjee Bar at Law was be appointed as receiver of the trust property, namely number 35 Ganesh Chandra Avenue, and of the rents, issues, and profits thereof, hereinafter referred to as the said property, with the power to get in and collect the outstanding debts and claims in respect of the said property, and with all the powers provided for in Order 40, Rule 1. Very important, Millard. So, two words, Millard. One is he is been appointed as receiver of the trust property. So, the property, the trust property, cannot be disputed because that's it. And that the receiver who was appointed had all the powers under Order 40, Rule 1D of the Code of Civil Procedure, except that he shall not, without the leave of this court, grant lease for a term exceeding 3 years, bring suits except suits for rent of ejectment where the rents are in arrear, institute an appeal in any court except for a decree in a suit for rent or ejectment where the value of the appeal is over such and such, expend on the repairs of any property in any period of 2 years more and a half of the net value of rental income to be repaired, such rental being calculated the amount of which the property to be repaired would be let in a fair state of repairless. Outgoings in either the owner or occupier share or both revenue, ground or other rents and proportionate collection, if any payable in respect of the said property, and is further ordered, the receiver shall have the power to expend on the repair of any property of such nature as would not ordinarily be let such amount as he may be decided on a meeting to be convened in the office after record so. Then, my lord, and the said receiver, my lord, page 58, my lord, 59, I start, and the said receiver and the parties of the advocate on record or any of them shall be entitled to apply before the court for direction or notice to the parties, the costs of such application being in the discretion of the judge, and it is further ordered that the defendants and all persons claiming them to deliver up, kindly Millard mark the word, all persons claiming under them to deliver up quiet possession of the said property. We'll at page 59.
Receiver and the parties. The first
Receiver and the parties on their advocates on record, or
Yes.
any of them, the said receiver shall be entitled to apply before the court, before the judge, for direction on notice to the parties, the cost of such application being in the discretion of the judge. And it is further ordered that the defendant and all persons claiming under them do deliver up quiet possession of the property. So the possession said property, together with all leases or leases, agreements for lease, kabuliyats, accounts, papers, memoranda, writings relating thereto, to the receiver. So the property was custodial legis, no doubt about it. And it is further ordered that the receiver do take possession of the property and do collect the rents, issues, and profits of the immovable property, and that the tenants and occupiers thereof do atone and pay their rents, arrears, and growing rents to the said receiver. And it is further ordered that the said receiver shall also have the power to use the name of the parties or to be indemnified out of the property. The further ordered receiver shall be sufficient discharge of such sums not necessary Yes, little below, and it would be 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. 14th line from the bottom.
Yes.
It starts in the middle and after incurring expenses. Has my lord got it?
Yes.
And after incurring the expenses for repairs, if necessary, the said receiver shall disburse the money in his hand in accordance with the trust deed. And is further ordered that the said receiver be, and he is also appointed receiver in respect of the money deposited in respect of the said property with the rent call in different names, and is further ordered that the receiver be at liberty to withdraw the money from the rent call, and such money shall be kept in one hand the nationalized bank. Is appointed receiver, last line, appointed receiver without security, but shall furnish the same within 4 months from the date of taking out a guarantee or an insurance of such and such, in respect of which shall come out of the estate, and further, or that all parties concerned and the receiver to act on the copy of the minutes of this order. This is an order of 1978. This shows, my lord, there are 3 things which are very important. One is, since it was a trust property and the rent of the property was used for the purpose of Dev Seva and Dev Puja, a receiver was appointed over the property. Number 1. The receiver had the power to take physical possession of the property and had been ordered to take physical possession of the property, collect the rent from the property and deposit it with the. So, Millard, all the 4 requirements under order 40 Millard has been specifically provided in this. And the very important thing is that the receiver was appointed during the pendency of the suit without any time limit fixed.
Yes.
Meaning thereby, Millard, that this receiver will continue until with the termination of the list or until further orders of court. Now, Millard, there has been no further orders of court in these proceedings where the receiver has been stopped from exercising his powers. So, if the property was custodial legis, even though, Millard, the suit was dismissed and restored from time to time, the receiver would continue in terms of Order 40 of the Civil Procedure Code. Now, Millard, I apprehend an argument that if the suit gets dismissed, then automatically the receiver gets discharged. Probably that's not the correct position in law. But here that argument will not apply because every time the suit was dismissed, it was restored. And the law now today is very well settled that if a suit gets dismissed and restored under Order 9, all interim orders, Millard, gets restored automatically. For that, there need not be a specific direction, because previously the law was, my lord, that if the court says that I'm dismissing the suit and all interim orders stands vacated, unless they are restored with all interim orders, the interim orders don't automatically get restored. This went up to the apex court, my lord, and the apex court finally held that no, under order 9, if a suit gets restored, automatically all interim orders gets restored. I believe, my lord, Justice Sinha had differed from that view, but the majority view was this. I shall cite that. But the reason why I cite this order is, that's a good copy. Which paragraph? Which paragraph? So let's kindly come to paragraph 9. I told you to keep it marked on it. This is 1962 Supreme Court, page 21. Supreme Court, page 21. Paragraph 9. The second contention of the learned counsel for the appellant is that the receiver appointed in the suit ceased to be a receiver qua the rights of the parties when the final decree was made by court. This contention leads us to the consideration of a question whether receiver appointed in a suit ceases to be such automatically on the termination of the suit. Neither Section 51D nor Order 40 of the Code of Civil Procedure prescribes for termination of the office of receivership. We must therefore look for the solution elsewhere. Some of the authoritative textbooks on receiver may usually be consulted in this connection. In Halsbury Laws of England, 3rd edition, volume 42, Lord Simmons at page 386, under the heading Duration of Appointment by the Court, the following statement occurs. When a receiver is appointed for a limited time, as in the case of interim orders, his office determines on the expiration of that time without any further order of the court. And if the appointment is until judgment or order, it is brought to an end by the judgment in the action. The judgment may provide for the continuance of the receiver, but in this regard, as a new appointment, judgment provide for appointment receiver, but in this regard, as a new appointment. If a further order of the court, though silent as to the receiver, is inconsistent with the continuance of the receiver, it may operate as a discharge. When a receiver has been appointed on an interlocutory application without any limit of time, it is not necessary to provide for the continuance of his appointment in the final judgment. The silence of the judgment does not operate as a discharge of the receiver or determination of his powers. So also the appointment of a receiver generally by a judgment in an administrative action need not be continued by the order or further consideration. In Kerr on Receiver 12th edition, chapter 12, under the heading Discharge of a Receiver, the legal position is explained thus. The appointment of a receiver made previously to the judgment in an action will not be superseded by it unless the receiver is appointed only until judgment or further order. In High Court on the Law of Receivers, 4th edition, the following observations appear. The functions of a receiver usually terminate with the termination of a litigation in which he was appointed. And when the bill upon which the appointment was made is afterwards dismissed upon demurrer, the duties of the receiver ceases as between the parties to the action. And although as between the parties to the litigation his functions have terminated with the determination of the suit,
He is still amenable to court as its officer until he has complied with his direction as to the disposal of the funds which he has received during the course of receivership. But an order of discharge does not necessarily follow in all cases because of the determination of the suit. And the court may, upon sufficient cause shown, either discharge or continue the receiver according to the exigencies of the case. The learned author makes a further distinction at page 986 between the following two classes of cases. Since the final decree in the cause is generally decisive of the subject matter in controversy and determines the right to the possession of the fund or property held by the receiver, it is usually the case that such decree supersedes the functions of the receiver, since there is nothing further for him to act upon. Although it would seem to be still necessary that a formal application be made for his discharge. But when the court by its decree does not attempt to decide the main question in controversy and leaves the receiver's possession undisturbed, it cannot be held to have the effect of operating as a discharge or superseding of his functions. Woodruff in the law relating to receiver in British India says Order 40 Rule 1A now expressly provides that the receiver may be appointed whether before or after the decree. As long as the order appointing a receiver remains unreserved, as long as the suit remains a lis pendens, the functions of the receiver continue until he is discharged by the order of court. The law may briefly be stated thus: if a receiver is appointed in a suit until judgment, the appointment is brought to an end by the judgment in action. If a receiver is appointed in a suit without his tenure being expressly defined,
Yes.
he will continue to receiver till he is discharged. That is what. So therefore, my lord, two questions will fall for your lordship's consideration. There is no formal order of discharge of the receiver, number one. Number two is this, my lord, that the fact that the list survives would be evident from a very, very simple. Whether the right to sue survives or whether the list is alive or not would be evident from the very simple fact that my learned friend now comes and says before your lordship that I have purchased the property. And he says that I have not been served with the notice. I could not because the previous restoration application was dismissed. But if the suit is restored, what I'm trying to show is that the cause of action survives, the disputes survive. Instead of Millard coming to an end, Millard, now the disputes have grown more. Some third party has come in during the pendency of the suit and there has been an assignment. This assignment could not have taken place in teeth of the order of receiver because their property was custodial legis, the receiver was in possession. I believe my learned friend's client was also one of the tenants in the property who had subsequently gone to purchase it from the one of the parties.
Yes.
This is so far as the defendant side is concerned. So far as the plaintiff side is concerned, if it is a trust property and the dispute are between two trustees, or trustees claiming right to office, till such time the last trustee dies, the right to sue survives. And even after his death, since it's a trust, the person who would have acquired a right by virtue of that trust deed, has a right to continue the suit against the person in whom there has been a further assignment. So, this is what I'm trying to say is this is not a case under Order 22, Rule 3 or 4. Here, is a case due to passage of time. All the plaintiffs have died. The last of the plaintiff died in 2021 or 22. Now, if that plaintiff has died, under the deed of trust, his legal heir gets the right to come in as the office of a trustee. So, under 22 Rule 10, he gets a right to continue. Now, when he comes before the court and prays for restoration, it comes to his knowledge that the property has already been sold when it was custodial legis to a third party. So there also, during the pendency of the suit, there has been an assignment of the title in breach of the order of 78. So either way, today the right to sue survives. Take out IP's judgment. That is, my lord, what I had tried to impress, my lord, upon, where is it annexed?
Annexed to
Page. Why don't you write down the page numbers? Why do you have to every time go on hunting and you can't write down a page number of order somewhere? That's the reason, my lord, if your lordship comes to page 15,
Yes.
my lord, this was the order by which, my lord, I was given liberty to apply. My lord, your lordship will find this is what, my lord, was my submission, my lord, at my lord, page 15, last line. So and so learned counsel appearing for the appellant submitted that the Shevachib of the plaintiff was joint and several. And even after the date of a Shebai, the right of Shevachib continued to vest in the living Shebai. The last Shebai died on 17th February 2021. Therefore, when the suit was dismissed for default on 16th February, the suit may have abated. It was not a case where the plaintiffs or the learned lawyer engaged by them failed to appear before the court when the suit was called on for hearing and the suit was dismissed for default. Also relevant is the question whether during the lifetime of the three Shebais, plaintiff 1, 3 and 4, the suit had abated against the defendant who had died on 11th February 1989. Assuming Mr. So-and-so's above contention to be correct that the right to sue survived in the surviving Shebai. All these questions needs to be appropriately addressed before the court on a proper application, which will be made. So, my lord, I'll have to show two things before your lordship. One is that the right to sue survived, and the suit regarding trust never abates. And on the other hand, that there were contesting persons who were claiming through or under the defendant who had died in 1989, adverse to the title of the deity, number one, and in violation of an order of court. I have showed one aspect. Now, my lord, if I may show your lordship the affidavit filed by my learned friend.
In affidavit.
Opposite. Where have we said that?
Yes.
It will be an affidavit of Pramod Kumar Lundia, afforded on 2nd of September 2024. Millard, his affidavit, Millard, if you kindly, Millard, very hurriedly, lordship will peruse it. His first point of law is that it is barred by limitation at paragraph 4. Paragraph 6, he says that the sole defendant died in 89. Thus, there is a delay of 35 years since the defendant's suit has abated as against the defendant. No cause of action survives as against the answering notices. Kindly mark the word, no cause of action survives as against the answering. This I have to show it does. Application based on contracted facts, then it's not very relevant. He goes on to paragraph 9 to say, in fact, today as on date, neither of the plaintiffs nor the defendants are alive and the petitioner cannot claim any right to sue or to file the application. Since all the plaintiffs have passed away, the present petitioner not being a party to the instant proceedings and not having been substituted has no locus standi whatsoever or even the instant suit. The said application is not maintainable. Then, my lord, in paragraph bereft of particulars, paragraph 7, he doesn't say anything. All he says, my lord, paragraphs 14, 15, 16, my lord, that it is lackadaisical attitude of the gate. What I wanted to draw your lordship's attention, my lord, is in paragraph 6 of my petition. I have said, in the year 2011, when the above order, that means the order of 78, paragraph 6 of my petition, paragraph 6, my lord, in or around year 2011, while the above order was still in existence and the receiver was still continuing to discharge his duties as per the order of 7 September 77, the heirs and successors of the defendant number 2 had created third-party rights in terms of the trust property and thereby had sold the trust property to subsequent purchasers in complete disregard and absolute violation of the order of this court. The said subsequent purchasers have also filed ejectment suits such and such before the learned court at Calcutta against the tenants of the property. The above evidence is still pending final adjudication. So, my lord, apropos this statement of fact, my lord, if your now lordship sees paragraph 6, which is at page 17, paragraph 17 at page 4 of his opposition, with reference to the contents of the paragraphs 1 to 6 of the said application, 7x, what was the matter record all allegations contrary are denied. It is denied that various order was passed from time to time in the said suit by this honorable court. It is stated that the plaintiffs are not taken steps to proceed with the suit. The plaintiffs are put to strict proof of the same. It is denied that any of the error referred to has done anything in disregard of the violation of the order of the honorable court. It is point to mention that although suits were allegedly filed in 2018, no steps have been taken by the petitioner since then. So, my lord, there is no denial of the fact before your lordship, my lord, that he has purchased the property in 2011. All he says is that I have not done so in violation of an order of court. Now, then he will have to show to your lordship, my lord, that the order appointing the receiver in 1977 were either expressly put to an end by an order of court, or there is any order of court which says that the receiver is hereby discharged. That's the reason, my lord, why I was citing 62 to show that the receiver continued. If the receiver continued, all the powers of order 41. So his client has basically interfered with the possession of the court of a property which is custodial legis. Interveners का भी देखो. Now, thereafter, my lord, paragraph 18 actually goes to show that the dispute still survives. Having said that there is no violation of the order of court, he says that it will be evident from the averments made in paragraph 7 of the petition that all the plaintiffs as well as the sole defendant herein had all passed away way back and the plaintiffs had not taken any steps whatsoever to get the parties in the said suit substituted. In fact, it will be evident from the pleadings in paragraph 7 of the petition itself that there has been huge delay and the laches on the part of not entitled to any relief. It is denied that the Shebachib of the plaintiff was also joint or several, or that even after the death of the Shebai, the right of the Shebachib continues to vest in the surviving Shebais, as alleged or at all. It is denied that after the death of the plaintiffs, the right to sue survives as alleged. It is denied that the suit was being proceeded by the plaintiff number 3. It is denied that the heirs of the family of Purnachandra Mondlik would continue to be trustees of the said trust, or that no family member of the settler would be entitled to claim any interest in the trust property as alleged or at all. So, Miller, this dispute continues. And the manner in which the property has been sold, Millard, is at page 62 of the petition. I think, Millard, I had shown this to your lordship, Millard. The manner in which it has been sold, Millard, Page 62, my lord, is the trust deed of 3rd of August, sale deed of 3rd of August 2011.
Yes.
And my lord, page 66, recital, my lord, I think I had placed it before you, lordship, because I find
Yes.
it smart. But I think
Yes,
I
it has
have
been
placed.
placed.
So, my lord, he goes on to say that as if after the since the trustees were not performing, so the defendant takes a call upon himself. The trustees are not performing. The settler revoked the trust, and therefore, by virtue of inheritance, I got the property, and thereafter I had the right to sell it. But, my lord, it does not take into note or suppresses the fact, if I may use the word, that there is not only a list pending, there is a receiver appointed, and the receiver is collecting rent and the property is custodial against. Both the parties to this document, my lord, have conveniently suppressed this fact. My lord, apropos this, my lord, kindly make a note of page 38, 39, that portion of the trust deed where it says that even if the trustees, page 38, 39 of the petition, my lord,
Yes.
my lord, and is hereby further declared, my lord, his lordship has got it, my lord, that the said trustees hereby appointed, that trustee hereby appointed, or by further trustee or trustees of this present, shall die or desire to be discharged from the trust of this presence, or refuse or decline or become incapable or unfit to act in execution of this trust, then in such then in such case it shall be lawful for the said trustee or other trustees for the time being of these presents to appoint by any deed or will any other person or persons of official or the official trustee of Bengal to be the trustee or trust of the said presence in the place and state of the trustee so dying or desiring to be discharged or refusing or declining or becoming incapable or unfit to act as aforesaid. And in making such appointment, the trustee shall be at liberty to exercise his full and absolute discretion in the matter, and upon such appointment the said property shall vest in the new trustee or trustees as the case may be, as if such trustee or trustees had originally appointed by this presence, and the trustee shall have power to comply with such requisition as may be lawfully insisted on the official on by the official trustee over the trust for management of such trust, provided always because the succession. Provided always that in default of the said trustee failing to exercise the power appointed by will or other document, or in case any vacancy or disqualification occurs, it is found impracticable to appoint a new trustee, the High Court of Calcutta shall appoint a trustee from amongst the heirs of the trustees appointed hereby, who may be found to be the best qualified to discharge the duties of such offices. And, my lord, the two paragraphs thereafter, my lord, and it is hereby further declared
Yes.
that the trusts hereby created shall be irrevocable. So, my lord, we have now two established facts. One is there is an irrevocable trust. So the office of the trust cannot fall vacant. If it at all falls vacant, the court has the parent's jurisdiction to appoint a trustee. Second glaring fact is that having noticed this, the court had taken the property under its custody, appointed a receiver, put him in possession of the property, and has done it without limiting any time. So, and said that it collect the income and put it to the trust so that the deities can be. That's the second glaring. Third glaring thing is that the suit during its pendency, my lord, the trust property got transferred to a person who now admits, or there is no dispute, that he is claimed through one of the defendants who is one of the defendants in the suit and a trustee at that point of time, or there was a dispute. So, and that the fourth and the purchaser now is trying to come and contest his title so far as the suit is concerned. So therefore, the situation that emerges is that in either case, from the plaintiff side also, there has been devolution of interest to the next successor, has to be who is the person who is the legal heir, the petitioner before your lordship. And so far as the defendant side is concerned, my lord, there has been a devolution or assignment of interest, although illegally, and they are also contesting. I may not make them party, my lord, if I can show before your lordship, which I shall address, that if I can show before your lordship, my lord, that this property has been sold in violation of an order of court, my lord. Supreme Court got to the extent of saying that first put it back into the possession which should had the property question not reached. For that, you don't even have to give the trespassers a hearing. The persons who are affected need not be heard because they are enjoying the fruits of an act which is in the teeth of an order of court. So it is the duty of the court, more so, my lord, when it's a trust property and it's a devotor property, that the situation needs to be restored. For that, my lord, I will show to your lordship, my lord, on the next day, that the suit has not abated, cannot abate, and therefore there is no question of any delay. All is required is, my lord, that the suit needs to be restored. I need to bring in these new purchasers and seek for further directions.
Date one.
Lord, in usual course, I can come back tomorrow, my lord, but tomorrow, my lord, after 2, I'm in some difficulty. I have to go. Very candid, my lord, I'll be out of station after 2 o'clock. So if your lordship can fix a date after 15th, I'll be going.
Then I will not be here.
Any other day, my lord. I just said that I'm not available for on 15th.
Mr. Shuman Dutt, learned senior advocate, appearing for the applicant. Due to paucity of time, hearing could not be concluded. Is this matter on? Bolo?
February 1st.
7th.
7th. সরস্বতী পুজো নেই তো? 4-5 তো।
On the next day, you will conclude?
Yes, yes. I'll conclude. Yes, please.
Record করুন। নামটা দিয়ে দেবে for intervener purchaser.
If they want to have a right of audience, my lord, then it will be a bit better. If you want to address court, then I can serve them a copy of the application. But you have not used any affidavit.
Lordship has.
I think
but there was no direction upon us to give affidavits. No, Lord, there was no direction to give affidavits.
Then, my lord, because otherwise this would become a technical glitch. You will go up and say, if at all I win or lose either way, my lord, then this will remain a glitch. Let them be heard.
দেখি order to দেখি সার্ভিসের by which order this direction was given for service? Mr. Arif Ali is for
I am for the notice numbers 10 and 11.
You have filed your opposition.
I have the one which Mr. Dutt was placing.
Uh-huh. You were there on that day? Yes. Obviously, 7th day. The intervener purchaser is directed to file affidavit in opposition within a week. A reply there to be filed within a week thereof. Within a week, you file your affidavit, reply in 2 সপ্তাহ 7th is here.
Reply in the meantime.
Reply in the meantime.
Okay.